Yes.
I am appearing for the respondent claimants, my lord.
Yes. Appellant. Yes, Mr. Singh. Yes.
My lord, this appeal of insurer is confined only to the quantum of compensation. It's a death case, my lord. A principal sum of 15,91,500 has been passed. Insurance company, my lord, has secured the entire sum along with the interest before your lordship's court.
Yes.
My lord, the deceased, my lord, was a 43-year-old man. My lord, on the basis of his alleged income of rupees 10,000 per month, the assessment has been made. My lord, as I stated earlier, my lord, 15,91,500 is the principal award. My lord, I draw your lordships, my lord, I invite my lord, on three specific issues as far as the quantum is concerned. My lord, number one, monthly income of rupees 10,000 is excessive.
What is the occupation?
My lord, he was a businessman. That's what, my lord, they claim. And he was doing business of, my lord, this seeds, mustard seeds, my lord. Mustard cake, my lord. After the, my lord, the oil is extracted, whatever is left over, my lord, it is used for, my lord, for this irrigation purpose. That's what they say. The leftover of that, my lord, after the extracting the oil from this mustard seeds. My lord, this is what they claim, my lord. I'll show it to your lordship, my lord. My lord, the first point, my lord, as I said, was monthly income of rupees 10,000. My lord, second was, my lord, under the collective head of general damages. My lord, I say collective head of general damages. My lord, 1,91,500 was granted. My lord, at best, my lord, taking the present days, my lord, this 10% increase twice, it would be 84.
How much was granted?
1,91,500. My lord, which is of consortium, funeral, and my lord, this estate. So, my lord, this 191,500 should at best be of 84,000 as of now, taking two escalations of 10%, 10% each. And my lord, third is interest 9% was granted, my lord. I humbly beseech your lordship, my lord, as my lord is kind enough, my lord, in all other matters, your lordship is granting 6%. It should be 6%. My lord, as far as number 2 and number 3 is concerned, I believe, my lord, my learned
1,91,500 on what heads it was granted?
My lord,
to wife.
My lord, it includes loss of estate 18,500,
Yes.
20% escalation.
Yes.
It includes funeral 18,000, my lord, 150,
Yes.
my lord, escalation of 20%.
Yes.
And consortium, my lord, it is 1,45,200. There were three claimants. All three were granted consortium 48,000.
Wife and?
My lord, the claimants were, my lord, the widow, daughter, and son. So, my lord, daughter and son, my lord, your lordship has already held, my lord, in so many matters, they are not entitled to. That is why, my lord, taking my lord's, my lord, other judgments into consideration, I say at best, maximum, it should be 84,000.
84 means
my lord,
40.
40 plus 4 plus 4, 10%, 10%.
Okay.
So, my lord, that is 48. And my lord, this.
And here it is awarded?
1,45,200. It should be 48. And my lord, loss of estate is 18,150. That is correct.
Funeral also 18.
Funeral also 18,150. That is also
that
correct.
Means 36 plus 36, 72 and 48,000.
No, my lord, 36 plus 30.
No,
not
36.
My lord, 36
and 48.
36 and 48. I'm grateful to your lordship. But it is 84. Approximately. A little more, 100, 200 more perhaps. 36 আর 36 কত হলো 36,300 আর ওইদিকে 48,000
And amount granted is 1,91,500.
lordship. So, my lord, as far as point number 2 and 3 is concerned, my lord, there is no dispute. My lord, my learned friend, my lord, perhaps would agree to that in order to avoid any further, my lord, controversies. As far as point number 1 is concerned, my lord,
Yes.
monthly income, my lord, that is my lord, I humbly beseech your lordship, my lord, it is an accident of 2015, 2015. My lord, the evidence what has been provided, my lord, I'll invite my lord, first of all, to the claim application, page number 4.
Yes, page number 4.
My lord, they claim item number 6, 10,500. That is true. That is what they claim. Then, my lord, the evidence of the widow.
That is page.
My lord, I'm sorry, my lord, evidence of the son, page number 11, if my lord comes to. The son has come up. Page number 11, if my lord kindly there, my lord.
Yes.
My lord, I would pray before your lordship to come straight to the cross-examination at the bottom. Is my lord there, my lord?
Yes, yes.
Since deceased was my father, I have not seen the accident with my own eyes. My father did not pay income tax. Today, right now, I shall not be able to submit any document showing the income of my father. I shall not be able to submit the income tax return. This is it, Milord. No documents to show the income of the father. This is the Milord, the only thing. Now, their
And
best
the complaint
evidence,
case is filed by?
Milord, the widow and 2 children.
Okay, widow and 2 children. Minor. Oh, this must not be minor. Major.
No, he's a major. He's the son. Widow, a son, and a daughter.
So in
The
the
son comes up,
claim petition, it is stated 10,500.
Milord, and in the evidence it says, Milord, I have no document to prove that income. Milord, the best evidence what my learned friend has, that is at page number 35, Milord. 35 and 36. My lord kindly comes to that.
Yes.
35, my lord, is there. My lord, this is a license form. Boro Chandghar Gram Panchayat. My lord, it says, my lord, that this victim, Bikroy Korto, Ashraf Hussain, my lord, Ashraf Hussain is the deceased, and he has paid, my lord, license of rupees 200.
License to carry on this, deal with this commodities.
Deal with this commodity, my lord. This is the license given by Gram Panchayat, my lord, it is at Nodia Gram.
Yes.
My lord, district Nodia, my lord, what gram, my lord, is Boro
Aliganj.
Chandghar. 36 also, my lord, is the same. Receipt of 200 rupees.
For registration of business, my lord, issued by the Gram Panchayat.
Yes.
License.
License.
Trade license.
Trade
Yes.
license.
My lord, license to carry on a business at Boro Chandghar Gram Panchayat. 200 rupees. This is the only evidence
That he used to do business.
that he used to do business. Whether he was doing it or not, but the evidence is this is the only thing. On the basis of this, my lord, learned tribunal, in its award, my lord, the award starts at page 56.
Yes.
Is my lord, may I just indicate, my lord, the relevant part wherein it has been dealt with? It is at page number 80. Is my lord, page 80, paragraph 82.
88,
80, my lord. The only portion, my lord, where this 10,000 issue
Yes.
has been dealt with. Paragraph 82, your lordship will kindly similar.
Yes.
Income of the deceased is, my lord, there.
Yes.
Income of the deceased was a notional one. As per the claim petition, it was rupees 10,500 per month. Arising from his business, both facts remained effectively unchallenged in this suit as discussed above. So, my lord, on this basis, 10,000 rupees has been assessed.
This is the
But-
dealing with minimum wage notification. In the business, minimum wage notification will not apply.
No, it will not apply, my lord. And in any event, my lord, this minimum
Whatever
wage-
it is, if the court thinks that it is this notional income is just and reasonable, the court can think that.
Yes, court can, my lord, court can
But
think
no
anything.
question of minimum wages there.
No question of minimum wages, my lord. And in any event, my lord, minimum wages at that point of time, my lord, in 2015, we are talking about. It would not
It is
be.
not, this person is not, did not used to earn
My lord,
wage.
I'm just giving the references. Learned
No
tribunal judge has
question.
brought in that reference. In that context, my lord, I was submitting. Otherwise, it
But
was not required.
What is this?
So, my lord, on that basis, 10,000 has been assessed.
10,000.
So, my lord, that is why I say, my lord, only on the basis of this Gram Panchayat receipt, a person's monthly income, 10,000 rupees, my lord, should not be accepted. That too, my lord, at Boro Chandghar, at, my lord, a distant village, my lord, in Nadia. My lord, your lordship will kindly, my lord, anything between 5,000 to 6,000, considering the year of accident. My lord, take note of that and, my lord, and dispose of this appeal.
Business, my lord,
10,000 rupees, my lord. I just missed out one, my lord.
my lord,
That- Second. My lord, in the general damages, my lord, 10,000 rupees was extra given for carrying the dead body. That also, my lord, need not be given. That is why I said, my lord, 84,000 is the composite total compensation. In general damages, my lord, I have stated 1,91,500 was granted. Total. It was inclusive of 10,000 rupees transportation cost. That is not there in Planacity. Your lordship will kindly delete that also. So, my lord, that is also a part of my general damages. Those three wings of argument. So, my lord, in short, my lord, I say, my lord, the monthly income, your lordship, my lord, whatever, my lord, thinks, my lord, between 5,000 to 6,000 on the basis of this receipt, because the son has come up and he has categorically stated that there is nothing else to show as far as the income is concerned. Nobody from the Gram Panchayat or any other fellow shopkeeper or any other person from the business or any bank account or any receipt of, my lord, doing the transaction, nothing is there. My lord, I would have accepted 10,000. Why 10,000? I would have accepted 20,000 had he shown the bank receipt that he's doing the transaction, that he's doing the business. Nothing else is there. Only on the basis of this receipt, my lord, the income of 10,000 rupees cannot be accepted. My lord, your lordship, my lord, I humbly beseech, my lord, consider anything between 5,000 to 6,000 and dispose of this appeal, my lord.
Yes.
I'm grateful to your
my
lordship.
lord, I am submitting my humble submission before lordship, my lord. My lord, my claimants, my lord, deceased used to earn rupees 10,000 and he regarding his business mustard cake, my lord, mustard cake business, my lord, there also took witness fully strongly, my lord. He rendered service as business of mustard cake. There are also proofness and documents already exhibited before this tribunal, my lord.
What documents? The Panchayat certificate, Panchayat
Page 11, my lord.
page 11.
35, my lord. Exhibit 10, my lord. License from, my lord, kindly see page 35.
That is there. That is there. Apart from this, any other?
How can it possible to proveness before this tribunal that she used to earn 10,500? Is it possible, my
Depends
it
upon
to
the
business
upon the nature of the
business carried on in our society in the village structures. There also mustard cake business, very important fact. In our agriculture farm or any of the animals or cow also, there also mustard cake also very important things over there. 10,000 per month, per day, 3,000, 300, above 300. In our so my lord, in the year 2000, per day income 300. That is very
So per day 300.
9,000, nah, maybe 10,000 as a 10,000 granted by Tribunal Lordship.
Suppose if it is taken as 9,000, how much it comes? You just calculate.
Milord, 9,000, your lordship, Milord, without any evidence, no bank doc, Milord, 10,000 rupees, Milord, is a huge amount in 2015. We are in 2026 today. Milord, you show any receipt. You could have brought any buyer. You could have brought any seller. You could have brought your fellow shopkeeper. You could have given your bank account. You could have given your receipts. Nothing.
In the villagers, my lord,
If it is in the
illiterate
village, then
person,
9,000 is more
they are
than
no.
sufficient.
You give the calculation 9,000.
এত স্ট্রং অপোজিশন 10,000 আমি তো দুটোর উপর কিছু বললাম না
Yes, Mr. Singh is only arguing, disputing this monthly income and that general damages.
general damage my lord I am consider I am agree my lord wrongly considered my lord 9,000
How much total awarded, total compensation?
Milord, it is 15 lakh. 91,500 is the principal sum.
my lord I am submitting before lordship my lord awarded amount my lord they are also kindly my lord deduct the that general damage consortium this is my lord 3 consortium granted for 3%, there would be only one my lord kindly deducted rupees general damage and my lord consider I am submitting before lordship my interest my lord 9% consider my lord kindly 6% my lord আর awarded amount जो 10,000 per month my lord this is lordship in our visitors in the they are also master cake business document easily lordship humble submission before lordship interest 6% my lord 9% very excessive my lord dependency of the family my lord 3 in the year 2015 300 400 must be required.
So 300 per day, that means you see it comes to, I think one day shops are closed, business shops one day.
No, my lord, in the villager size only full
Hello.
open my
100
lord.
into 300, 9,000. If you
Milord,
say
your
according
lordship is
to,
accepting the income in totality, Milord.
ঠিক আছে no
yes, 9,000. That is why I have asked you to give the calculation.
নব্বই হাজার আরে দাঁড়ান তো করছি তো
1,000 টাকা দিলে কি হতো
মাল্টিপ্লায়ারটা কত ছিল
14 হবে
এটা তো চেক করতে থাকো ভুল না হয়ে যায়
You are using calculator or manually?
Milord, I'm using calculator as well as manual, Milord, so that there is no mistake. Because I'm giving Milord the entire total to your lordship. Milord, as per my lord's Milord views, it is coming to 13,44,000. Your lordship, will kindly have a look, Milord.
Okay, including the damages.
Yes.
It was awarded 15 lakh.
91,000. 15,91,500. Milord, 2015 is the year of accident. No documents, nothing.
$15,91,000.
Lordship, 500. লুট है क्या সব সরকারি টাকা এগুলো
Yes, record an order. Learned advocates for the parties at present are learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1888 and is aggrieved by the judgment and award dated 23rd day of November 2023 passed by learned Additional District Judge, First Track, Third Court, Noida at Krishnanagar in MSC case number 13 of 2017. Stop. The case of the claimants before the learned trial court may be summed up thus. On next para, on 31/5/2015 at about 10 a.m., the deceased Muhammad Ashraf Hussain, alias Ashraf Hussain, along with some passengers riding a van rickshaw coming from Palashi to Devogram, all on a sudden, at that time, all on a sudden, a lorry bearing number WB 533957 in a rash and negligent manner with high speed dashed behind the van rickshaw, stopped. As a result, the passenger of the van rickshaw got serious injury, stopped. Local people shifted the injured to Shaktinagar District Hospital at Krishnanagar, where the injured Muhammad Ashraf Hussain died on that day. Stop. The said accident was caused due to rash and negligent driving of the driver of the truck. Stop. Pursuant to the filing of the case, notice was issued upon the opposite parties. The opposite party vehicle owner did not contest the case. Stop. However, the opposite party, New India Assurance Company Limited, contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. এখান থেকে কোট করে দেবেন, হ্যাঁ, hence it is ordered. এই পেজ আমি ফোল্ড করে দিচ্ছি। The appellant, New India Assurance Company Limited, being aggrieved by the judgment and order passed by the learned trial judge, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the claimant's respondents peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that his client is aggrieved with the quantum of compensation awarded by the learned trial court. Stop. Learned advocate further submits that the learned trial judge, without considering in the absence of any document with regard to income, has considered the monthly income of the victim as rupees 10,000 per month, which is excessive. Learned advocate also submits that considering the evidence adduced, the monthly income of the victim cannot be more than rupees 6,000 per month. Learned advocate for the respondents claimants submits that the victim had 3 dependent members of his family and thus earning of rupees 10,000 is not unreasonable. It is further submitted that village shopkeeper will not have sufficient documents to show the income to show his own income. Thus, no error is committed by the learned trial judge in considering the income of rupees 10,000 per month. Stop. It is also submitted that the order of the learned trial judge need not be interfered with. I am not recording your consent with regard to that general damages. I am recording your objection. Upon hearing the learned advocates and considering the facts of the case, it appears from record that the claimant's respondents filed documents to show the occupation of the victim. Stop. As no documents was filed with regard to the income of the victim, the learned trial judge considered the income to be rupees 10,000 per month. Upon considering the evidence of PW1 and considering the nature of the occupation, although there is no serious error with regard to consideration of rupees 10,000 per month by the learned trial judge, but this court is of the view that it would be just and reasonable to consider the monthly income to be rupees 9,000 per month. Stop. In the event the monthly income is rupees 9,000, the annual income comes to rupees 1,08,000. 25% is added to the future prospect, which is 27,000. The total monthly income comes to rupees 1,35,000. 1/3 should be deducted on account of personal expenses, and the annual dependency loss comes to rupees 90,000. Stop. The multiplier of 14 applied, the total dependency loss comes to rupees 12,60,000. Stop. Further, the claimants are entitled to general damages of rupees 84,000. Stop. Thus, rupees 13,44,000 is the total compensation which comes by arithmetical calculation. Stop. However, this court is of the view that compensation of rupees 13,50,000 would be just and reasonable. Hence, this appeal, FMA 468 of 2025, stands disposed. The judgment and award dated 23rd day of November 2023, passed by learned additional district judge, first track, third court, Nodia at Krishnanagar, in MSC case number 13 of 2017, stands modified to the extent that the claimant's respondents will be entitled to rupees 13,50,000 along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The appellant, New India Assurance Company Limited, shall deposit the compensation amount along with interest before the Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event the amount awarded by the learned trial court is already deposited, no further deposit be made. The claimant's respondents will be entitled to withdraw rupees 13,50,000 along with interest at the rate of 6% per annum, including accrued interest upon compliance of necessary formalities. The balance amount, if any, along with accrued interest, be returned to the appellant, New India Assurance Company Limited.
My lord, my lord, last humble submission before lordship. In the year 2015, SBI, State Bank of India, their my lord interest rate was 8% to 8.75%. My client very suffering the financial disturbing. My lord, kindly lordship consider 7% lordship.
No,
My humble
6%.
submission.
In all matters, I am granting this 6%. Uniformity is being maintained. Yes.
My lord, this is a insurance appeal, my lord. I have come up against an award of rupees 44,51,000, my lord. 44,54,096. This is the principal award. It's a death case, my lord. A
Yes.
my lord, 155-year-old my lord, gentleman going as a pillion rider on a motorcycle. My lord, he fell down and died. There are 5 claimants, my lord. Widow, son, and 3 daughters, my lord. All 3 daughters are married. My lord, I have come up with your lordship on a number of counts. My lord, first one is non-involvement. And secondly, my lord, in the broader category, my lord, is quantum. Non-involvement and quantum. My lord, quantum, why I say, my lord, as far as the consortium is concerned, my lord, 1,60,000, 160 was granted.
Consortium of
My lord,
40,000 each.
40,000 each, my lord. To 4 of the claimants.
Yes. Now, with regard to non-involvement, you argue.
My lord, consortium, I'm sorry, my lord, consortium in total for 5 claimants, 2 lakhs, 40,000 each, I'm sorry, my lord, 2 lakhs was granted. But I say it should be 40,000 or 48,000 for the widow, my lord. And my lord, as far as the other part is concerned, my lord, 3 daughters, my lord, they all were married. Sarla Verma, my lord, is very clear, my lord, married daughters, my lord, are not entitled for compensation. So, my lord, if married daughters are taken out of these 5 claimants,
The
the
personal deduction.
I'm grateful to your lordship, my lord, it becomes 1/3. My lord, your lordship will make calculation on the basis of 1/3 if your lordship at all decides. And after that, my lord, in howsoever number of claimants they want to distribute, let them distribute. But let them not, my lord, subterfuge, take advantage of excess number of claimants.
Probably in this regard, married daughter, I have passed an order.
Yes, my lord, only
have
last
that
week,
order.
last week, my lord, your lordship said
Last
that.
week or 10 days ago, just.
Yes, that, my lord, they are not entitled to, my lord, to take advantage of personal deduction.
Yes.
They can be claimants.
They may be legal representative.
Maybe legal representative.
Yes. So far the deduction is concerned.
But, my lord,
so that order I passed.
yes, my lord. That is why, my lord, I say that as far as the deduction for personal expenses is concerned, my lord, it should be 1/3 and not 1/4. Now, my lord, on the first point, that is with regard to the non-involvement. My lord, the accident.
So vehicle number was mentioned.
Yes, vehicle number was mentioned. My lord, the accident had taken place on 21st March 2014. Your lordship will kindly take note of this. 21st March 2014. May I invite my lord, to page number 20, where the first information report is there. 20.
Yes. 156.3.
Lordship.
Not legible, the copy.
When those copies are not legible, I also suffer from the same problem. But whatever little assistance is required, if I can give to your lordship.
If it is there from the trial court records.
Yes, my lord. But I am giving the specific dates, my lord. In case of any doubt, my lord, my learned friend would please correct me. And my lord will check up, my lord, with the trial court records. My lord, page number 20, if my lord is kindly coming to.
Yes.
Page 20, my lord, on the, it's the first information report. On the right top, my lord, is the date when the FIR was lodged. My lord, this FIR has been lodged on 10th September 2015.
By whom?
My lord, this is, my lord, has been lodged by one Information received, my lord. It has come through, my lord, the court complaint case.
No, who has lodged this complaint? Any victim's family, claimants, or somebody third party?
My lord, that reference is not here in
Oloka Baudi,
Aloka Bauri, my lord. Aloka Bauri is the
wife of
widow.
late
Is the
Dhiren
widow.
Baudi.
Aloka Bauri is the widow.
Oloka Baudi is the widow.
Lordship. Now, my lord, I join issues here that the accident was of 21st March 2014. And now,
And claim case when?
my lord, that is another shocking thing, my lord, 2019.
Yes.
My lord, page 20, I was indicating to my lord, my lord. FIR on, my lord, 10th September 2015, that is 1.5 years after the accident.
What is the reason for lodging this 156.3 at a belated stage?
My lord, 156.3 application is perhaps not a part of this.
Yes, page 22.
Page 22. This is, my lord, petition 279.10. It is not legible, my lord. That is why, my lord, I also couldn't
consider certify করবেন
হ্যাঁ
all certify করবেন এই যে।
এটা একটু ডাক করে পড়ালেই তো হতো স্যার, এটা তো দেখা যাচ্ছে। My lord, paragraph number 5. If my lord can read, my lord, if my lord
Yes.
can read, my lord, firstly your complainant was busy for the funeral ceremonies of her husband, and thereafter, due to sudden death of her husband, your complainant was very much mentally shocked and her mental position was not normal, and such she was not in position to file any case, hence the delay. 6. Matter was duly informed to Raniganj PS. OC asked the complainant to take shelter in the open court of law. Not a ridiculously absurd statement, because there are 5 claimants, 4 children, my lord, who are asking for the money before the court. They all are major. None bothered, my lord, to inform the police. An allegation is being made against the police that we went to the police and police had to go to the court. For 1.5 years, my lord, nobody went. And if my lord kindly come, my lord, to page number 24, the seizure.
Yes.
The very first column, my lord, or the statement, date and time of seizure, 29th December 2015. Further 3 months thereafter. So, my lord, FIR 1.5 year, seizure 1 year 9 months. And then, my lord, the claim case, if my lord comes to, my lord, the award.
That is 2019.
2019. Accident of 2014, after 5 years, my lord, the claim case is filed.
Page?
Just because limitation was not there in the earlier act. So, lordship sees, my lord, after 5 years, they are coming up to file a claim case. My lord, from what angle, from which side, and how insurance company would know, would appear, would contest, and would fight out the case? No information given, no intimation whatsoever. Complaint is after, my lord, 1.5 years, without informing the company at all. Why not? If at all, my lord considers in this particular case that the vehicle was involved, assuming, my lord, it goes against me, my lord, this is an absolute fit case to make the owner responsible and liable to make payment. More so, for the reason, my lord, the owner or the driver, my lord, comes up before the court and says that yes, this accident was there. If you knew this accident was there, then why didn't you inform? Statutory provisions are there, my lord. Those are not just to read the book. You don't comply, and if you don't comply, then you suffer. Why only insurer should be made to suffer in these kind of cases, my lord? I kill somebody and I say my insurer would pay and I don't inform my insurer. Insurer comes to know when the claim case is filed after 6 years or 5 years from the date of accident. The statute provides that you inform the insurer if you want to take advantage of the policy.
Because in this one column they have mentioned any claim been lodged with the owner or insured, if so, with what result? Yes, but with no effect.
Where is that? Yes, you show me. I'm out.
So was this put in cross-examination
No, my lord.
that any
My lord,
claim?
no, my lord. They need to show it, my lord, to the only oral evidence would not do that I did so. You show it by a document, give one letter.
No, they can go to office and say
They
that
can go
this is the problem. Simply say that they will go to office and say, I have suffered a loss to either the owner or to the insurance company.
My lord,
Owner will refer them to insurance company.
my lord, that would not do, my lord. They have to prove their case.
Yes, that is why when they get this proper advice, they come to file this case. Otherwise, they go from pillar to post. This
My lord,
victims.
they got the proper advice, my lord, to go before the police station after 1.5 years. 5 claimants, all majors.
No, when was the
And
charge
my
sheet
lord,
submitted?
my lordship is considering the situation in a remote village where the people are not educated. I understand. Here, the victim was an employee of ECL. He was a permanent employee. My lord, the compensation is 50 lakhs.
And when was this charge sheet submitted?
My lord, had it been a village rustic person, my lord, I would have appreciated this.
In some cases, it is there.
Yes, but my lord, in this case, it is not. You claim for 50 lakhs. My lord, 50 lakhs is not a meager amount. My lord, this is a public exchequer's money.
No, right. But this, when was the charge sheet submitted? That is the delay in the complaint case?
My lord, Caesar list, my lord, I have shown to your lordship, my lord, it's at page number 24.
Yes.
Charge sheet is at page 25, my lord, kindly comes to.
Yes.
It is dated, my lord. Final report on 31st December 2015. My lord, it's my lord, does it not prick
31st December
2015? Second line, my lord. Final report, charge sheet number 352 by 15. My lord is at page 25.
Yes,
Second line from the top.
Yes.
Final report, charge sheet number so and so, date 31st December 2015. My lord, does it not prick our, my lord, conscience? 29th December, my lord, vehicle seized. 31st December, charge sheet filed. As it was made ready, it was only there.
And after 4 years, the claim case filed.
After 5 years.
2015, 19.
2014 accident.
No, charge sheet. Let us go from this.
Yes, charge sheet 2015.
Yes.
After 4 years from the charge sheet, my lord, this claim case has been filed. My lord, limitation was not there. I know that. Under the statute, my lord, they are entitled to. But this inordinate delay, your lordship has to look into this. It is not a claim of 1 lakh, 2 lakh. My lord, you are claiming a principal sum of 50 lakhs. Without, my lord, following any of the provisions of law. Now, to prove this involvement, that I have shown, my lord, these discrepancies, I would invite your lordship, my lord, to show what eyewitness has said. My lord, victim was a pillion rider, as I said, on a motorcycle. My lord will kindly come, my lord, to page number 18.
Yes.
Tukuman Hasda. I know the victim. Incident took place on 21st March 14, caused by motorcycle number so. He was sitting as a pillion rider. Today I have filed my examination in chief. In cross, my lord, I have not obtained any summons from this court. The petitioner number 1 called me to depose in this case. I was standing at a distance of 10 feet from the place of occurrence. My relative was admitted to Anandalok Hospital and I went there to visit him, but I have no document to that effect. Soon after the accident, I know the victim, Dhiren, the investigating officer interrogated me about the incident. The advocate wrote my examination in chief. I cannot read English language. No reference, my lord. Anything that yes, you took the victim to the hospital, you informed police, nothing. It simply says, my lord, the interrogating officer interrogated me. No botheration about informing the police even. How much it is to be believed? Now, my lord, I will add on to this. My lord, at page number PW5, another eyewitness, my lord. My learned friend, my lord, has, my lord, given, my lord, one 4 pages supplementary paper book. If your lordship kindly comes to that, my lord.
Yes. PW5.
PW5 টা কোথায় দাদা? আরেকটা eyewitness আছে, এটা আপনি এতে দেননি। PW5 award বলছে there is PW5 also. দেখুন তো একবার। My lord will kindly come, my lord, this supplementary paper book. My lord has
এই
got the 4
সাপ্লিমেন্টারি
pages.
পেপার কইটা দিন। এটা তো এটা কি? ও এইটা। Yes.
My lord, the first one is OPW1. He is the driver of the motorcycle, or the person who was riding the motorcycle in which the deceased was sitting.
Yes.
On 21 March 14, I was driving the motorcycle. Sheikh Hussain is the owner of the motorcycle. At about so and so, I along with the deceased, fell down from the motorcycle. He was shifted to KM hospital, but the hospital authority refused. He was taken to Asansol hospital. He expired there. I cannot recollect whether the registered owner of the motorcycle authorized me to drive the same. I have brought my voter card, driving license. Cross-examination. On the date of incident, the victim was known to me, but he is not formally known to me. I shifted the victim to Raiganj hospital as well as hospital in Asansol. I have not reported the incident to the local panchayat and any other authority. Your lordship will kindly say nothing, no information, only coming before the court 11 years after the accident and saying that yes, he was there, he died, I took him to the hospital, no hospital records about this. I did not inform the police. I only came to the witness box to say that yes, he was sitting there as a pillion, he died. So give the compensation. This vehicle was involved. Now, my lord, in this same supplementary paper book, OPW2. OPW2.
This is OPW1.
My lord, OPW1, my lord, was the driver.
Oh.
What I had read earlier. My lord, award describes this. My lord, award is at page 43. I'll just indicate, my lord, if your lordship kindly comes to page 49. Is my lord there, page 49? My lord, it
40.
refers to PW1, PW3, PW4, and PW5.
Yes.
My lord, this PW5, my lord, I am not finding, my lord, this in the paper book.
The PW5 is discussed in the judgment.
Yes, my lord, at page 49.
Page 49. PW5, which paragraph?
My lord, third
Okay,
paragraph.
third paragraph.
So it is evident. from the
PW1, 3, 4, and 5.
My lord, PW5, my lord, I am not finding anywhere.
PW5 deposition.
Yes.
Let us see from this thing. The lower court records, trial court records.
Lordship.
এই trial court record টা একটু দিন।
দাদা এটা কি? এই PW5 টা কি?
আমি দেখি না।
এখানে অ্যাওয়ার্ডে আছে, আপনার পেপার বুকে নেই।
কেউ নাই। কোর আছে এখানে।
হুম?
কোর পর্যন্ত আছে।
আচ্ছা, এটা কি ভুল টাইপ হয়েছে না এটা কি?
কোর পর্যন্ত আছে।
ও তো আমি দেখিয়েছি তো।
সার্টিফিকেট তুলে যায় না।
এখানে ভুল আছে, তাহলে এটা দরকার জানা উচিত।
সেটাই করবে।
My lord, PW5, my lord, perhaps my lord is. Maybe a typographical error, my lord. They were PW1, 2, 3, and 4.
For real certificate.
So PW1,
1 is widow, my lord.
PW2,
Two is
that is
the-
the employer.
Yes, on behalf of the employer.
PW3
3 is the eyewitness.
is the eyewitness.
I had read out, my lord.
PW3,
And PW4, my lord, the doctor.
4 is the doctor.
Lordship. And then, my lord.
Yes, PW5,
Oh, Tali Khan name.
Pradeep Bauri.
Pradeep Bauri is, my lord, it is mentioned, but it is not there a part of this paper.
I know certificate they are not given.
Yes, you may go through this from this.
Lordship.
See. So that is why I always insist on
Yes,
production of the trial court records.
I'm thankful to my lord. My lord, this is another so-called eyewitness, PW5. In the cross-examination says, my lord, the IO interrogated me. I was at a distance of 10-15 feet. My lord, he says, I saw the accident. That is only relevant, my lord, and the rash and negligent driving of the motorcycle rider was there. That's what he says. And in cross says, IO interrogated me. I was at a distance of 10-15 feet from the place of occurrence. I do not know Aloka Bauri. I also did not know the injured. I signed the medical papers in the hospital at Asansol. If he has signed the medical papers in hospital in the Asansol, if the vehicle number is there, my argument goes. It is not. It's again a false statement. I signed the medical papers in Asansol. On the date of incident, I came to learn the name of injured, Dhiren Bauri, from his family members. Soon after incident, the police came to the place of occurrence. Your Lordship will kindly see the velocity. Soon after the incident, the police came to the place of occurrence. And at that time, he interrogated me and I narrated and the manner of incident and number of the offending vehicle. The police reduced to write my statement. Several number of persons were also present there and they were also interrogated by the police like me. And their statement has also been recorded. My house is 7-8 kilometers away from the place of occurrence. I was going from my house to Raniganj and PO is place of occurrence is within my house and Raniganj. Not a fact that I have not seen anything or I am giving false evidence. My lord, police came, police recorded, took down the number, took the statement of this man as well as others, and absolute blank. It's all vanished into
Only with regard to UD case. Only a UD case was instituted.
My lord, UD case also would be referring to the number.
Yes.
Where is that? I
And
put this
UD case
question to
definitely has to be instituted.
myself. But the number should be there. If it is there, my lord, then I am out.
Because in all accidents, you see, UD cases are instituted.
My lord,
Postmortem is done.
Yes, my lord, the moment the body went to the hospital, there has to be.
An UD case and postmortem.
It has to be. It has to be. But my lord, where is the reference of the vehicle which he says that he had given to the police? It is not there. For the first time, my lord,
IO was examined. IO or the who conducted
no,
the
no,
EO?
no, my lord, I was not examined.
And the EO who conducted the UD case?
No. But their own, my lord, statements, the way it contradicts the records, it shows the falsification. It's a blatant lie. They say that they have reported everything to the police, including the vehicle number. It is all my lord, all blank. Police is not aware. For the first time after 1.5 years, it is coming.
This person is cited as witness. What is his name?
My lord, his name is Pradeep Bauri. My lord, the charge sheet, my lord, I have shown to your lordship, page 25 it was.
25. Yes, Pradeep Baud is there.
My lord, this is being prepared, my lord, nearly 2 years after the accident. If the Pradeep Bauri was there, then what prevented the police who took the name of Pradeep Bauri then and there on the spot to write down, my lord, the number of the vehicle and the other things? You are, my lord, lodging an FIR after 1.5 years, wherein you got the information on the date of accident from this place of occurrence. My lord, the story has to be believable. For 1.5 years after knowing the accident, after knowing the vehicle number, after knowing the injured, you did not do anything. You seized the vehicle 1 year, 9 months after the accident. And within 2 days, you file charge sheet. This is one part with regard to the involvement when everything was silent. And now I was coming on the second part, whether because of this accident, the victim died or not. Accident happened, whichever the vehicle was. There was an accident, victim was taken to the hospital. Victim was a pillion rider, he fell down. What hospital is saying? I would invite your lordship, to the doctor who had conducted the post-mortem.
That is page?
The evidence of the doctor, is at page number 19, 19.
Yes.
My name is Dr. Shotinath Banerjee. Is my lord there?
Yes.
I conducted post-mortem of deceased in connection with the Asansol UD case number. My lord has rightly said, UD case number. But nothing, no vehicle number, nothing was there. Aberration was found on the right knee and left elbow. Your lordship will kindly underline this part. Aberration was found on right knee and left elbow. This was the injury. This injury may be occurred by falling from bike. This injury also causes heart attack. There is possibility that heart attack may be caused by falling from a bike due to injury. Victim died because of heart attack.
Where? In the postmortem report?
Yes. I'll show that. And the injury was aberration injury on right knee and left elbow. I have prepared. I'm sorry. I have prepared post-mortem report of deceased Dhiren Barui, which bears my signature. Cross. My service tenure is so and so. Usually, cause of death is mentioned in the post-mortem report. If the death is caused by injury, it is written death is due to effect of injury, which is anti-mortem in nature. My lord, in all post-mortem report, my lord has seen because of injury, anti-mortem in nature. But I have not mentioned the said statement in the post-mortem report. I have mentioned acute massive cardiac attack as cause of death. Dead body of disease was identified by so and so and so. It is not mentioned in the PM report that patient party met me at the time of holding. My lord, last paragraph. It is fact that the patient died due to active massive cardiac attack. The injury, your lordship will again, my lord, kindly take a note of this, my lord, the next sentence.
Yes.
The injury, is my lord there, my lord? The injury mentioned in the post-mortem report are not major injury. So those injuries are minor in nature. Such kind of injury may cause or may not cause the death. It is not mentioned in the post-mortem report that such kind of injury caused the death of the victim. After receiving summons, I appeared today to depose. My lord, post-mortem report is annexed at page 27. It is not very legible, my lord. The trial court records are here, but the contents of the post-mortem report are legible, which have been stated by the doctor. Minor injuries. These are aberrations. Only on the right knee and left elbow. And the death was because of cardiac arrest, heart attack. But I put this question to myself.
Yes.
Death has not occurred because of the injuries sustained in the accident. My lord, Motor Vehicle Act is very clear. I need not trouble your lordship. Use of the vehicle, and the reason has to be, my lord, accidental injury or death. In this case, it is neither of those. Accident injury is not there. Death is not.
Injury is there, falling from the bike.
Yes, but my lord, the injury is not related to the death.
No, falling from the bike injury is there.
Yes.
Thereafter, he was hospitalized.
My
But
lord,
whether that injury is the cause of death or the Death is from cardiac.
That is from cardiac arrest. That is
Okay.
for sure. That the doctor has said. Death is from cardiac arrest.
Injury is there,
Injury, abrasive injury is there. It
falling
is,
from the bike.
yes, it is minor. Your Lordship will kindly see what is the extent of injury, what the damage is. My lord, I'm sorry, my lord.
Yes.
I suffer a cardiac arrest. I suffer a cardiac arrest, no injury. My death would not be related to any injury, my lord.
No.
Normal death. I suffer a cut in my hand, and immediately thereafter I suffer a cardiac arrest. My lord, would it be said that because of that cut in my hand, I suffered the cardiac arrest and that is why I died? No, this cannot be relatable. This is what the doctor has said. These are abrasive, these are the minor injuries, and the death was because of the cardiac arrest. These two cannot be clubbed together.
Postmortem's report is legible copy is there. Let us see.
Milord, it is there in the trial court because this is Milord again. But Milord, he has stated the contents of the entire post-mortem report. He has said the injuries are minor. Those are very, Milord, abrasive injuries. And the injuries, Milord, at which part of the body the injuries were? Elbow and the knee. And the person died because of the cardiac arrest. Any injury for any reason whatsoever, Milord, if thereafter he suffers from the cardiac arrest.
So
Milord,
two persons were there riding. One
yes,
is the driver, the other is the.
This gentleman who died, he was, Milord, a pillion rider.
Okay. The other person suffered injury. The
Person suffered injury, Milord. He said that he was driving the vehicle. Milord, that is, Milord, the OPW1. He was driving the motorcycle. He has given the evidence before, Milord, before the trial court. Milord, cardiac arrest, Milord, it has to be shown that it is related to this particular injury. I am walking, I suffer cardiac. Do I say that I was walking, that is why I suffered cardiac? I was sleeping and I suffered cardiac. Can it be said I was sleeping, that is why I suffered cardiac? No, it cannot be. Cardiac is, there are so many other reasons. This minor injury has to be shown to be the reason for this cardiac. Doctor says, no, it cannot be because the injuries are minor. And where the injuries was not, I was indicating to your lordship, it is in the elbow and the knee. And they are minor. It is stated very clearly. And it says that the death did not occur because of the injuries which are ante-mortem in nature. That he has stated. That is the part of the post-mortem report. So death has not occurred because of the injury. If it is mentioned in the post-mortem report, how can that injury be, Milord, related to the death? If the post-mortem is absolutely clear on that. And if this injury or death, Milord, cannot be related to, Milord, this motor accident claim case, Milord, then there cannot be any award against the insurance company. Act is very clear.
let me see. Hey, trial court
Lordship.
recordটা দেখি একটু. ওনার ক্ষতি করবে You see, if you can read it out, this
Lordship.
regarding the cause of death, what is the terminology used?
Immediate cause, acute invasive myocardial, means myocardial is heart attack.
Myocardial.
This myocardial, something is there in fission. It is again stated natural. The natural is there in the bracket. দেখুন দাদা আপনি যদি আমাকে কারেক্ট করতে পারেন যদি কোনো ন্যাচারাল and the external injuries, abrasive knee and elbow, it is also written so whatever is this doctor himself conducted the postmortem. He himself came before the court. Every single statement, what he himself has signed this. Every single statement, what he says, it cannot be doubted.
The very on the said day itself, he died, or he was admitted to hospital.
This postmortem was conducted on 22nd March 2014,
and the
accident is on 21st March. So yes, on that day he died. This is next.
That day he died.
So this postmortem report is of the next date. So there is no delay, in the accident or injury or this heart attack. Injuries are minor. Death is because of the heart attack. Injuries are confined to left elbow and the knee. And the death is not related to any injury which is ante-mortem in nature. If that is not related to any injury which is ante-mortem in nature, then the Motor Vehicle Act is not attracted here. This was my second point. First point, was involvement. Second, was this injury is not related to this accident. The death is not related to this accidental injury, whatever it was, the minor injury. Third point, I was invited, your lordship, I had indicated to my lord that in view of 3 married daughters, your lordship, this general damage, this consortium which is of 2 lakhs, your lordship will kindly, bring it down to 40,000 or 48,000, That was, my third point. I will not elaborate on that, because these are admitted facts.
And the personal deduction.
Yes, personal deduction was my fourth point. That was on under the category of quantum. Quantum A, general damages, should be 84,000 in total, inclusive of 48,000 consortium. General damages should be confined to 84,000. Total general damages which was granted, that was 2,30,000. 2 lakh plus 15 plus 15. I say it should be brought down to 84,000. This 230 should be brought down to 84. The next point, on quantum B, in view of 3 married daughters, deduction for personal expenses should be 1/3 because of 2 claimants remain, mother and son. For married daughters, if they want to give their share, I don't dispute that. It is up to them. They are the daughters. But don't take advantage of personal deduction. This is what my lord has held. So that was, the other part. And, the penal interest was granted. Your lordship, if my lord, if at all your lordship holds against me, it should be 6%.
It was granted?
10% penal interest was granted, if
it is not paid within time.
It is not within time, So ultimately, it should be brought down to 6% per annum, in sum and substance, I am not troubling your lordship, with various other judgments again, which will again, take 2 hours. Rajamma, Anil, Saritha, my lord, with regard to the non-involvement, and my lord, with regard to this, the injury, my lord, which is not leading to the death, my lord, that is because of, my lord, this heart attack, which is very clear, and not antemortem in nature, that is also very clear. Injuries are minor, that is also very clear. So, my lord, these are with regard to, my lord, injuries not leading to the death, and my lord, third point is quantum. These are, my lord, the sum and substance of my submission.
Okay. Yes.
Extremely grateful to your lordship.
My lord, death has been proved, my lord. PW page 19, my lord. Yes, injury was caused heart attack. The injury may be occur by falling from the bike. The injury also caused heart attack. There is possibility that heart attack may caused by the falling from a bike due to injury. Doctor evidence are clear, my mention here. PW4, my lord. PW4 clearly mentioned before the trial court that the accident due to effect of the injury, the heart attack has been done. So PM report already done due to the doctor, and evidence are clear that due to effect of the injury caused the heart attack and he was died. This is the fact is there. Now the question, my lord, even the company has been produced to witness there, my lord. PW1 driver, PW2 owner. If the opposite party produce that witness and they are admitting the fact, no records are requirements or documents are required because owner admit the fact the accident, driver fact the accident occurred due to fault of the driver. So no other documents are required. Reference by the Supreme Court.
No, who owner filed written statement.
Owner evidence is there. Company produced the witness, my lord.
Which page?
Owner appeared, my lord. I had shown to you. Owner appeared and said that my vehicle was involved.
PW?
My lord,
OPW2.
Oh, OPW2. That is the vehicle owner.
yes.
Produced by the company, your my lord.
Okay.
OPW1 is the driver. If the documents has been, evidence has been proved that the vehicles were involved in the accident, there is no other documents are required. No other documents are required, my lord. This is the department of the Calcutta High Court. Justice Rajesh Singh and others there. Para 8 and 9, my lord. Owner admitted, no record of other documents there. Owner evidence before the trial court produced by the insurance company.
Okay.
After evidence of PW1 and PW2. So insurance company window had been closed. Window has been closed by the said own witness, and there is no chance to open the window for lighting the said case for defense of the insurance company. Ar kono lighting nahi. Defense kora kono scope nahi. That scope is there. Insurance company produced the witness, not produced by me. So no chance of the insurance company lighting to open the defense on the claim case there.
Yes. And
My PW1 on cross aviation, page 13. PW, page 13. Page 15. There is no cross that the married daughter not entitled to get a compensation.
anyway, that's a point of law. Okay.
Yes, my lord. Now the points of law is there, my lord. Affects the courts of the events. The married daughter is entitled in the case is there. Lighting them, my lord. Major son are also entitled and also
See, entitlement is one thing. Nobody is disputing that the legal representatives are entitled, but whether in personal deduction they should be taken into consideration.
This is the case is there, my lord. You can see the my lord. One for deduction. Marriage daughter not excluded, my lord.
Okay. Yes.
All claimants are entitled, my lord. Honorable Justice Deepan Datta recent judgment there. All claimants are entitled loss of consultation. Just wait a din, এটা ভালো দিন করা চলবে। দিন করা চলবে।
ঠিক আছে। Yes.
My lord, delay, FIR delay is not a factor. Recent judgment, my lord.
And this claim delay?
Delay.
No, claim delay.
Delay is not a factor.
No, FIR delay is not a factor. Very well. There are decisions. But question is the delay in filing claim petitions.
That is time, but no. There is a provision is there.
So no limitation.
66 subsection 3, no limitation is there, my lord.
So at any point of time, a claimant can file this claim case.
Yes, my lord. There is no provision, time limitation is one day there.
Okay.
There are 30.
Oh, this is what Rajkumar Das.
Yes, my lord.
Rajkumar Das is injury case.
Well, that is
In
Raj,
case,
Oh, the delay in FIR.
delay FIR.
Rajkumar Ajay Kumar is the injury case.
Oh, Rajkumar versus Ajay Kumar. That is the injury case.
Yes, my lord.
And Rajkumar versus National, this is this delay in FIR.
Delay.
And delay in MSc, no problem. Even 10 years also you can file.
My lord, Supreme Court has said, my lord, inordinate delay, my lord, MSc case has been dismissed. Supreme Court has affirmed that. Inordinate delay, my lord, it has to be seen. My lord, you delay in FIR, you delay in charge sheet.
No,
you delay
FIR, yes, this decision will come to his help. And after the FIR is filed, charge sheet is submitted. Very well, even charge sheet is submitted at a belated stage.
Yes, my lord.
After filing the charge sheet, he can come to the court.
But your lordship will kindly see this, my lord, the sequence. Sequence, my lord, the way it has been adjusted, my lord. Immediately, my lord, the Caesar, the very next day charge sheet. You were sitting tight for 2 years.
That's a different issue in
My
non-involvement.
lord, I am saying, my lord,
These
your
are merits.
my lord, your lordship will not look into this in isolation, my lord. This chain of events, my lord, I am just, my lord, showing it to your lordship, how these things have happened. My lord is this, my lord, deciding, my lord, in totality, my lord, whether it is genuine or not. First of all, it is clean or not. And then thereafter, my lord, the quantification comes. Lord, these are all nationalized.
Delay as because there is no period. So no delay is mentioned in the claim
But
petition.
my lord, falsification of the eyewitness.
Yes.
He says police came. He says police recorded. He says
Yes,
they
yes,
gave everything. So, my lord, how do we digest these?
Delay and then this.
These blatant lies before the court. If police is not to be believed, then don't believe the charge sheet. Throw it away and then you prove your case. You say I said everything to police.
No, police
has
has submitted the charge sheet.
But my lord, police on the date of accident, the eyewitness says on the date of accident, police recorded everything. Where is that?
Even the case is acquittal.
Then you throw away the eyewitness. Either you throw away the eyewitness or you throw away the police.
In the case acquitted, there is no effect which has been.
That's all?
Yes, one.
Yes. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 24/7/2026.
24. Still new question.
এটা একটু ইয়ে করে দিন। সাপ্লিমেন্টারি পেপার বুক ঠিক করে দেবেন।
My lord, in this case, I am for the appellant. Only consideration is tribunal
Who is
awarded,
appearing for the response?
tribunal awarded rupees 12,900 only. 30%
Injury case?
Injury case. 12,900, 5,800 proved medical expense, but tribunal assessed 5,000 and 2,100 per month. Total 12,500. A meager amount.
So you are not satisfied with that? When? Date of the incident?
Date of incident 2000, my lord, 5. 3/11/2005. Doctor assessed 30% disability. Tribunal did not consider that.
On what grounds it is awarded?
My lord, kindly see page number 16 of the paper book. 16. Total 12,900. 1,000 medical
Yes,
expense.
injury, what is the maximum amount? In
My lord,
injury case?
Your lordship is asking in view of the amended notification.
163A.
163, my lord, amended notification of 2018. Urmila Haldar's judgment, my lord.
Yes.
That says that percentage of disability, my lord, the maximum is 5.
No, that is death case
My lord,
probably.
I'm saying,
Two lakh
my lord, the maximum compensation, either injury or death is 5 lakh. My lord, injury, my lord, then percentage of injury then has to be taken into consideration. And then, my lord, with that, my lord, the percentage of injury with monthly income, it has to be seen. Whatever there is, my lord, that is to be granted. So, my lord, in this case, 30% is the injury, what is they are claiming to be, whatever it is, my lord. So, my lord, 30% of 5 lakh is the maximum what one can pray for your lordship, or what can be granted under the, my lord, I'll just show that notification to your lordship if there is any.
Yes, I admit.
The maximum, my lord, 30, my lord, your lordship will consider this is the notification. If it requires.
30 is 1,50,000
Yes, 1,50,000 maximum.
maximum.
If he can prove his case.
No, that is he has proved before the trial court.
But I'll show that why it is wrong.
Yes.
I'll join issues. But the maximum, my lord, the limit is 1,50,000. That he agrees, my lord, that he would not dispute.
1,50,000.
That is the maximum limit he can get if he is entitled.
Okay. Second schedule.
My lord, second schedule is not coming into the picture. Your lordship will, yes, my lord, this is there.
Yes, 163A. Fatal accident, 5 lakh.
Into percentage of disability.
That is 5 lakh into percentage of
5 lakh
disability.
into 30 is 1,50,000.
Permanent disability.
Yes, I'm coming to that.
So whether he was examined, no, you see, above 40% is by the board. Below 40%, 40% and below by a registered medical practitioner. This is the position of law.
Yes.
So did this doctor treat you?
Not it. Not it.
This doctor did not treat you. How many days you are in hospital? 10 days in hospital.
Fracture right fibula and medial malleolus with displacement.
Okay, let us see this.
Yes.
Page
Page 47.
47.
Page 47, doctor's report. My lord, kindly see X-ray report. Item number 5 below. 311, item number 5, serial number 5, doctor's report, last page.
Yes, last page.
Yeah. Below 5, X-ray report dated 3/11/2005, fracture right fibula and medial malleolus with displacement. This is a injury. So 2 fractures are there.
Yes, so what do you say?
Milord, I had given your lordship, Milord, this notification.
Yes. That is the maximum limit.
Milord, maximum, Milord, I am not on that. First of all, Milord, the maximum, Milord, that boundary is set. Maximum is 1,50,000 if he succeeds. Milord, your lordship will kindly come, Milord, to the second part of that. B. My lord has read, Milord, that B.
Yes.
First part.
Yes.
Compensation, Milord, so and so.
That is also maximum
Milord,
limit.
into percentage of disability as per Schedule 1 of Employees Compensation Act.
Yes.
This injury, Milord, has to be as per the Schedule of Employees.
So let us consider that Employees Compensation Act.
Under Employees Compensation Act, Schedule 1, Milord, this injury is not there, fracture injury.
Okay.
It is not there.
So the Lanet judge has not committed any error.
Rather, he has given in access, Milord. He was not entitled to anything. That is one part. Milord, this is Schedule 1. Fracture injuries are not mentioned here. Fracture injury in the right leg. That
Yes,
was it.
part 1 and part 2.
Milord, the notification speaks about part 1.
Part 1.
So part 1, Milord, the injury, what the claimant suffered, right leg fracture is not mentioned.
So minor injury, let us see.
Milord, I am coming to that.
25,000.
The man, then, Milord, he comes to the second part. Milord, I'll go further up. Because this speaks about permanent, Milord, disablement. This notification. Provided that the minimum compensation in case of permanent disability. Second part, your lordship sees. Notification. Right below that.
Shall not be less than 50,000. Provided.
No, Milord.
Minimum compensation.
Not on C, Milord. I mean B only.
Okay, fixed compensation of 25,000.
Milord, above that.
Accidents.
Provided that minimum compensation in case of permanent disability. Was it a permanent disability? No. Private doctor, permanent partial disability.
It is 163A admitted portion.
Lordship. His permanent partial disability. He is not even covered. Milord, he is hit by B first, B second. Both. Because Employees Compensation Act, he is hit. Schedule 1, he is not covered. And second, it is not a permanent disability. He is also out by this. Now, further, Milord, what he claims in the claim, Milord, this is as far as the notification is concerned. He will not even get 25,000. Second part, Milord, in the claim application, your lordship will kindly come to page number 1.
Page number 1.
Monthly income 3,500, column 6.
That is page 1 of this workman's.
Milord, page 1 of this paper book.
Yes.
I'm sorry. Page 1 of this paper book.
Yes.
Milord, monthly income 3,500.
Yes.
Lordship will kindly come, Milord, to this evidence part, page number 23. This claimant. Is my lord.
23.
23, Milord, is the evidence of the claimant. PW1.
Where is 23? It's not here in the paper book.
23, my lord, the relevant part is at page 24. Page 23 starts, my lord, the evidence of
Page
PW1
23 of,
paper book.
no, page 23 of the trial judge's order.
No, my lord,
No.
I'm running page 23. Page 23 of the paper book.
The page 21 এর পর তো আর কিছু নেই।
Your lordship will take note of my paper book, my lord. Your lordship will.
Anyway, you see, verify
Yes,
the
yes.
paper book.
Your lordship will kindly say, my lord. The evidence of PW1 starts at 23. I'm at page 24 at the very last
Okay.
sentence.
Yes,
My lord, monthly income 3,500.
yes,
This is what he has pleaded.
yes.
This is what, my lord, he comes up in the witness box and he states 3,500 into 12 is equal to 42,000. He is out of 163A in totality. 40,000 rupees. My lord, on the day before, a matter was going on before your lordship under section 163A. Mr. Pahadi raised the plea, my lord, that above 40,000 rupees per annum one is not entitled to, my lord, under the Motor Vehicles Act 163 capital A. My learned friend agreed to that. But he said in pleadings, it was more than 40,000, but in, my lord, in evidence, it was 2,500. That's what the pleading was. Your lordship accepted that it is coming down below 40,000. So he would be entitled for 163A. My lord, the judgment of, my lord, Kanai was given to your lordship that if the income is more than 40,000 per annum, one is not entitled to, my lord, the claim case was liable to be dismissed initially. Judgment is here before, my lord, not the Honorable Division Bench. Bhaskar Bhattacharya. It was shown to your lordship. My lord, the argument was of my learned friend that no, the income is below 40,000. In this case, the pleading as well as the evidence is all above 40,000 rupees per annum. He is not entitled by way of this income as well to come under the, my lord, this ambit of 163
No,
capital A.
was rash and negligent proved?
My lord, rash and negligent, I'm not getting into that. I'm saying whether,
Question is, was that if that is proved,
lordship.
then 166 can be considered also.
No.
No, if rash and negligent.
No,
is
no,
proved-
my lord, I'll join my issues here. I'll join issues here. My lord, if the case is under 163 capital A, my client would not fight, my lord, this rash and negligent driving at all. He will not even argue before the court. My lord, my client, if it is the case under section 163A, my lord, the dealing with
No,
the
one issue was there. Did the accident take place due to rash and negligent driving on the part of the driver of the trekker? So what is the findings of the learned?
my lord, I will not get into that. I will not invite your lordship into that.
Whether that issue was
My lord,
hard.
even if it is, my lord,
Was
my lord,
there.
may I, my lord,
Let us see
your
what was
lordship
the
will
issue.
not convert this 163 into 166
No,
at
but
all.
this issue was framed.
My lord, maybe, but it is a case under 163A. Learned tribunal judge has not converted it into 166. I fought the case for 166, 163 capital A. At the appellate stage, my lord, my lord, I gave it a go by my ground. I did not fight on that.
I
because
can
it is
show the Supreme
163A.
Court decision where the 163 turned into 166.
You come with the decision, okay?
Yes,
You also
I
come
will
with the
show the
authorities.
the Supreme Court decision.
Yes, record and
I'll-
order.
Yes.
Learned advocates for the parties are present. Heard learned advocates. Let this matter appear for further hearing on. Hey, দেখুন তো। Next week. Hey, then 26 at 12 p.m.
27.
Thank you.
My lord, next matter is also mine. Your lordship will take it up any day, my lord, whenever my lord is convenient. At the
Next
earliest.
matter means 4.
4 and 5, my lord, is also mine.
Oh, same date. I'm making it hard.
Lordship.
Yes, you are appearing. I tell
Yes, yes, he is appearing.
এই আইটেম 3 আর 4 এ সেম অর্ডার করে দিন, ঠিক আছে?
3, 4 and 5.
3
3 and 5 are together.
3 টা আলাদা আছে,
3 আলাদা আছে, 4, 5
4 আর 5 এ 3 আর 4 5 টা তো এক অর্ডার করে দেবেন 27 তারিখে।
on 27th.
Yes,
At
12 p.m.
Item number 6, Your Lordship, I am representing the appellant. Respondent, just now I have called, he told that he will appear virtually. That's why I bring him.
You are- Yes, Mr. Tiwari, you are for the one of the respondent.
Next case.
Next matter.
Oh, next case.
So fixed 2 p.m.
Oh, next case is at 2 p.m.
Yes, fixed at 2 p.m.
Two matters of mine. Both are.
Both 6 and 7.
He's the appellant.
And the
No, in which is 7 you are appearing. Oh, both are different cases.
different.
7 you are appearing. So
Six other side.
7 the appellant is present.
Yes, I am there.
So let 7 be taken up. Mr. Rajesh Singh is for the one of the respondents.
No, that is.
No, that is different matter.
Different. Rajesh Singh, this is the railway matter, Your Lordship.
This is against railway.
No, not real. Okay. This is oh, this is not that claim case. Not that motor accident claim case. So anyway, let's take up this matter. Yes.
Your Lordship, this case is filed by the wife of the victim appeal for the death of her husband in an untoward incident in a railway accident. First, Your Lordship, I am coming to the factual matrix of the case, which is in my paper book, page number 5, Your Lordship. Yes. Paper book, page number 5. The brief fact of the case is that the accident took place on 23rd October 2021 afternoon hours. The victim, who was a resident of Falta, on 23rd October 2021, early morning came to Diamond Harbour Station along with his wife, Sulata Kanji, the nearest and convenient rail station from his house. And after purchasing a return journey ticket from Diamond Harbour to Ghutiari Sharif, both of them boarded a local train from Diamond Harbour Station. He was on his way to Ghutiari Sharif to his relative's house and also for some personal work purpose. On their way, they alight at Sonarpur Junction Station to catch a train for Ghutiari Sharif, as there is no direct train service available on that particular route from Diamond Harbour. After completion of his work and a brief stay at his relative's house, they again came to Sonarpur Junction Station and boarded a down Diamond Harbour bound local train from that station to reach his house at Diamond Harbour. As the train was heavily crowded, the victim and his wife could not board in the same compartment. The victim's wife boarded adjacent compartment and the victim's only managed to stood near the gate of the compartment, and due to overcrowding, he fell down in between Sonarpur and Subhasgram railway station in the railway premises itself, between kilometer post number 18/5 and 18/70. At the time of returning, the incident of accident occurred and the victim died at the place of occurrence itself. The victim's wife, who was in the adjacent compartment, came to know from other passengers that some person had fallen down from the adjacent compartment. Subsequently, when the train reached Diamond Harbour Station, she alighted from the train and waited for her husband, but could not find him in the station after a lot of searching. Then he informed his family members about such incident and also informed his brother, who was a resident of Sonarpur, his brother. In the meantime, on being officially informed by the booking supervisor of Sonarpur railway station through a memo, which was treated as first information report, investigating officer of Sonarpur GRPS reached at the place of occurrence at 5:15 p.m. and prepared the inquest report in presence of available witnesses. I have annexed all the documents in the tribunal also. Photocopy of such FIR and memo inquest report are annexed. And annexed was one ticket was recovered from the body of the victim, which was seized. And seizure list was also produced in the tribunal below. Photocopy which is marked with Exhibit A. Thereafter, the body was sent for post-mortem for further legal proceedings. This is the factual matrix of the case. Now, in my claim application in the tribunal, I have specifically pleaded that the victim was traveling with his wife. At the time of returning, the victim wife was also accompanying the victim. But the case mainly dismissed on the ground by the tribunal that one inquest witness were not present at the time of occurrence. This is the main contention of the tribunal, that the inquest witness and the seizure witness was not present at the place of occurrence.
Time of incident?
Time of
Day.
incident, I am coming. The document I have annexed. So here is judgment. Yes, my lord. The time of incident is before 4:40 p.m.
That is
afternoon.
okay, before 4:40
Before
p.m.
4:40, because
Afternoon.
afternoon at the time of return. And from the journey ticket also it will corroborate. And from the memo was issued at 4:40. So the incident occurred before that. What the memo says, as per reported by SM, one unknown male person aged about 45 years knocked down and dead body lying kilometers so and so. So on the basis of the station master memo, the investigation was done. The station master memo also, it is prepared by the station master sitting in the railway office. He is not the direct eyewitness. Thereafter, the investigation comments. In the inquest report, your lordship, inquest comments at 5:15 hours. Incident reported 4:40 p.m. in the afternoon, and soon Sonarpur DRPS arrived, your lordship. And 5:15 p.m. the inquest begins, and the entire inquest was done almost 1 hour, and it was completed. Investigation closed on 16:20 hours. This is paper book 61, the investigation report.
Page 61.
My lord, I seek your lordship apology. The LCR has come because in my paper book the 62 pages, next page is not there. So investigation report is in the LCR itself. And from the LCR, that investigation report, which is marked that exhibit A4.
This is 174.
174. And from this report, it is crystal clear that the victim fell down from the running train. In the inquest report, it is quite mentioned by the investigation officer of the GRPS. And investigation comment at 5:15 hours, investigation closed 6:20 hours. And most importantly, and during this time, the seizure list was prepared. During this time, the seizure list was prepared, your lordship. The seizure list is marked as exhibit by the tribunal
Page.
page 64 of my paper book, your lordship. '64 seizure list, your lordship. Date and time of seizure on 23rd October 2021 at 5:35 hours. That is in between the total investigation procedure. Investigation commenced 5:15 hours, closed at 6:20, and seizure was done at 5:35 hours. Where the place seized at kilometer post number so and so towards Subhasgram and
Date
down
of
track.
seizure 23. Okay, that is 23/10/2021.
Yes, your lordship.
Date of
Time-
incident,
Date of incident 23rd October
same.
2021.
And that is the date of seizure.
Yes, time of seizure is 5:35 p.m. Inquest done on 5:15 p.m. Total inquest was proceeded for 1 hour, 16:20 hours, and at 5:35 the ticket was seized during that inquest, and that was seizure list was prepared separately. Where the place of seized at kilometer post number so and so towards Subhasgram and down track. From whom seized? The deceased person Sachin Kanji, from the victim's possession. Now the name of the seizure witness is Debu Maiti and Prosenjit Kanji. I am coming to that point, your lordship. On that basis, the case was dismissed only because that Debu Maiti and Prosenjit Maiti is not the eyewitness.
They are seizure witness.
They are seizure witness. This is the main reason of dismissal in the tribunal, that they are not the eyewitness of the incident. They came later to the place of occurrence. And your lordship, journey ticket, which is marked at exhibit A9, was also brought on record in the tribunal, which was marked at exhibit A9 in paper book 65.
Yes.
This is a valid return journey ticket, and the timing
Of the victim.
Yes, your lordship. Page 65 of my paper book. Diamond Harbour to Ghutiari Sharif, adult 1. This is return journey ticket, Ghutiari Sharif to Diamond Harbour. So at the time of returning, this incident of accident occurred, and there is no dispute regarding the place of occurrence.
See,
Yes,
this
your
is
lordship.
from Diamond Harbour to Ghutiari Sharif.
Yes, and return.
That means it is a break journey, not a direct journey.
Direct journey. This is a
It's a
return
break journey.
Break journey, your lordship.
So return is also a break
Return,
journey.
yes.
And,
Return is,
and the incident took place between which station?
incident took place, your lordship. Sonarpur and Subhasgram at the time of returning. Because at the time of returning, they have to come to Sonarpur first. From there, they have to change the train. With that same return journey ticket, they
That
have
is Sonarpur to Subhasgram.
Subhasgram.
So their place of residence is Diamond Harbour.
Diamond Harbour.
From Diamond Harbour to
They
Ghutiari
came
Sharif.
to Ghutiari Sharif in the morning.
From Ghutiari Sharif, they have to come to Sonarpur.
From Sonarpur, they have to change the train to reach
So
Diamond
it
Harbour.
took place between Subhasgram and Sonarpur.
Yes, your lordship. There is no dispute regarding the place of occurrence and the direction of incident of accident also by the respondent. There is no dispute. They admitted that the incident occurred in the railway premises. And body was found also outside the railway track. Ticket I have also annexed. That is the ticket. And main, this Debu Maiti and Prosenjit Maiti was not the inquest to eyewitness. That's why the landed tribunal disbelieved the seizure list. Now, most important, your lordship, in this case, what I want to highlight, as per RPF-GD, RPF is the internal investigating agency. As per RPF General Diary, your lordship, which is part of the DRM report itself. That I am highlighting to your lordship. This is
Yes.
now, your lordship, that railway has submitted an internal inquiry report, which is called the Divisional Railway Managers Report, your lordship.
That is inquiry by the police authority, inquiry by the railway authority.
Inquiry by the railway authority.
Yes, page.
That is DRM report is, your lordship, it's a collective document, it collectively marked as exhibit. This is DRM report is from page 14 to page 49 of my paper book. Page 14 to page 49.
Page 40.
Page 49. From page 14 to page 49 is the total DRM report, inquiry report. I am just highlighting page 56 of the DRM report. Page 63, your lordship.
Page 56.
Page 56. That is the continuation of DRM report in my paper book. No, 56. Page. Your lordship, I am just 35, 36, 36. Pardon my lordship. Page 36 of my paper book. This is the details of report and diary entry by the internal investigating RPF, which was also marked as exhibit by the tribunal. Now, in this DRM, this RPF report, it is written that the ticket recovered in presence of the RPF person itself.
36. Okay,
Yes.
well, what is the statement?
The statement, page 36, this is the details report. This is one general diary entry by the RPF.
Not legible copy.
That is their copy.
Illegible copy.
That copy was supplied to them by the respondent
It is
itself.
not- It should be legible copy, type copy.
Of one Samsung type copy you should have submitted in the lower tribunal. It is written in the last column that the it is written on bleeding spot wearing such and such full pant with belt white ganji, sky color, red color pant, and the GRP, SRP, Sonarpur, Paul with staff of Dome in the dead body carrier attended the spot. From search, the near and area, GRPS Sonarpur, SIS Paul found 3 pant, one Samsung mobile phone was also recovered. Apparels also, one railway ticket bearing number so and so, that was also recovered. In presence of the Railway Protection Force itself, that they have produced their document, and which is collectively marked as exhibit. So from the investigation done by the GRP and from the internal investigation done by the Railway Authority RPF itself, from this, it is crystal clear that the ticket was recovered from the place of occurrence.
Yes.
So from the bona fide part, it is clearly established that the victim was a bona fide passenger from the evidence of the documentary evidence available in the record. And in the most importantly, in the entire WS and the DRM report, they have not present any credible evidence that the victim died otherwise. It is a case of knockdown, or it is a case of dash down by railway, or it is a case of suicide or murder. That was not produced. So prima facie case is clearly established by the appellant that the victim was a bona fide passenger. He fell down from the train. And most importantly, her wife also adduced evidence in the lower tribunal, which is also available on your in the LCR, your lordship. She was also accompanying at the time of journey.
That is page, cross-examination of wife.
Cross-examination of wife.
That is, yes, examination of wife.
Cross-examination, this is in the cross-examination I am coming. Photocopy of delay contribution, cross-examination of wife. There it is there in the DN report. Yes, in the page 58 of paper book. This is the cross-examination of his wife, who was accompanying with the victim. Page 58
Yes.
of paper book. The witness cross-exam, the affidavit in chief was written as per instruction. The applicant filed one affidavit in chief so and all the documents which are marked exhibit A1, A2, A3, A4, A5, A6, A7, A8, and A9. Now the FIR was marked at exhibit A3. Investigation report was marked at exhibit A4. Final police report also marked at exhibit A5. PM report exhibit A6. Railway ticket exhibit A7. Seizure list exhibit A8. And
Okay,
original...
did this applicant exhibit her railway ticket also?
No. Her railway ticket, because she was not aware that the ticket, her ticket will be required for the... She was not aware that her ticket was required for the filing the case. But husband ticket was found victim's possession.
Yes.
Yes, that ticket was found from the victim's possession. As the case was later on filed after 1 year of the incident, it is not possible. The applicant did not know about that the claim application was to be filed, and for that my journey ticket, her journey ticket also recovered.
No, because it is not a reserved ticket. Had it been reserved ticket, no question.
No question was there. This general ticket. Applicant was not aware. Victim's ticket was found. That's why victim's ticket came into the picture. And the ticket was also verified from their part. It is also mentioned in the DRM report. Ticket was verified by Railway Authority itself. Now the cross-examination, the deceased Sachin Kanji is my husband. The incident took place in afternoon on 23rd October, your lordship. I was traveling in the same train by which my deceased husband was traveling. In the cross-examination, same train. I was in ladies compartment, whereas my husband was in general compartment. My husband fell down from running train. He was standing near the door of the compartment, and due to rush of passengers, he fell down. When I reached Diamond Harbour, I did not know that the incident had taken place. My husband did not deboard from the train at Diamond Harbour. He did not attend my telephone call because his phone was switched off. After the accidental fall, his phone was switched off. I could not find out my husband and Diamond Harbour. GRPS Sonarpur told my father-in-law that my husband met a railway accident. Then I went to GRP and they told that my husband had died. I did not report to the matter to statutory authority, not a fact that I have filed a false case to get commission. From this cross-examination, it is clearly established. The victim was, wife was traveling along with her husband, though in separate compartment.
But may you leave my note when matter is called in court.
No, because the matter should be concluded today.
I am coming back. Not matter will be called in court number one.
Anyway, let him continue. Thereafter, you try.
Yeah, my lord, you take a note. If my lord, I am held up there. Kindly make it tomorrow. My lord. Lord.
মিনিট 10-15 5 মিনিট লাগবে।
Yes, go on.
Now the main point of dismissal, my lord, person signed in the scissor list, as I have told, statement before RPF. The person, the two person who signed in the scissor list, they told before RPF that they did not want to the place of occurrence. That person was never examined before the tribunal itself. Only contention in the, if your honor goes by the judgment, only that part. The scissor witness is not the eyewitness. They went later to the place of occurrence. That's why the scissor list was disbelieved by the learned tribunal. And scissor list was disbelieved, and learned tribunal held that applicant was not a victim, was not a bona fide passenger. Hence, it is not a case of fell down from the train. Now, my contention is again is that from their report, it is crystal clear that the ticket was recovered from the accident spot, both in presence of GRP and RPF. As per the RPF GD, it is crystal clear.
Yes, what is the ground for the railway authority to not to award the claim?
Only.
But the railway authority themselves.
Railway authority themselves, only the scissor list they disbelieve. The photocopy of order, the photocopy of Railway Economic Tribunal final judgment 52 to 56.
No, rejection by tribunal is this scissor witness were not examined.
Yes. Scissor witness is not the eyewitness of the case.
Yes.
They went later to the place of occurrence.
No, scissor witness can establish that this person has purchased the ticket.
Yes, scissor was done. They are just the scissor witness. Because in the inquest witness and scissor witness did not necessarily
Scissor
be the
was not
eyewitness.
disbelieved.
Scissor witness was disbelieved. Yes, in the judgment 55, page number 55 of my paper book, your lordship.
Yes.
The Debu Maiti, page number 55, your lordship. And more so, tribunal hold that they are not independent witness. Because his brother, the Debu Maiti, who is the Debu Maiti? The victims, Sulata Kanji's brother, who lived in Sonarpur. He contacted with his brother. He went to the place of occurrence directly from Sonarpur.
No, from the applicant side,
Yes.
who are examined?
Applicant side, the victim was, applicant wife was examined.
Only applicant.
Yes, because there is no other eyewitness. Applicant was traveling with this.
No, the brother-in-law of this applicant, he went to the spot.
Because he is not at all the eyewitness.
No, but he went to the spot, found the body.
Went to the
Anyway, regarding the place of body place where the body was found, as well as the recovery of ticket.
Recovery of ticket.
This cannot be disbelieved.
This cannot be disbelieved.
But the incident that was not witnessed.
Pardon, your lordship, incident
was not witnessed by the scissor witness.
No. That is there. Inquest witness is not the scissor witness and not the eyewitness of the incident. On that ground, the case was dismissed. In this case, the eyewitness was witnessed her husband's journey itself. She was the eyewitness, Sulota Ganji himself. Only the reason is that inquest witness and scissor witness are not the eyewitness of the incident. That's why the claim was dismissed and scissor list was dismissed. Hence, scissor list of ticket is not credible. But the scissor is done, your lordship, from the DRM report itself. That from the RPF also. DRM report as per RPF GD, which is part of their record. Which In that record, it clearly mentioned that the ticket was recovered in presence of both GRP and RPF. That was clear. So from the prima facie, the case is established that the victim was a bona fide passenger, and the police investigation and from the circumstantial evidence, it is clear that the victim fell down from the train. And had it been a knockdown case, as per the railways manner of investigation rules, only in case of exceptions, the compensation cannot be allowed, such as suicide, self-inflicted injury, murder.
If it is a knockdown, it does not fall under untoward incident.
Untoward incident. So no evidence was brought on record in the tribunal by the respondent that its case falls under the exception. They admitted that the place of occurrence under the railway premises. Now, my lord, there is the rules, railway passenger manner investigation rules. It is very interesting. Report about untoward incident. Rule 3. Any railway servant, including guard and driver of the train, any railway servant, including guard and driver of the train, on coming to know of occurrence of untoward incident, shall report the incident immediately to the nearest station superintendent. This is rule 3. And rule 4 says, if an untoward incident occurs at the station, the concerned station superintendent shall immediately arrange for medical assistance to the injured passenger, report such incident within 24 hours. And rule subclause 2, if an untoward incident occurs in midsection, the guard of the concerned train shall inform to the station superintendent. So had it been a knockdown case, the driver was the best witness, because if somebody dashed by train, then driver was the best witness to incident, witness. Driver was never examined. Had it been a knockdown case, it was examined by the respondent that such train, the victim was dashed down. So from the circumstantial evidence and the document produced by the respondent itself.
So it was in the daytime.
In the broad daylight.
No, which month?
The October month.
October month, 5:40.
Incident occurred before 4:40.
Oh, 4:40. Yes,
yes. And the entire time sequence of event matches, right from the purchase of ticket and at the time of returning, everything matches. Seizure also proved beyond reasonable doubt, because in presence of both investigating agencies, that ticket was recovered.
Okay.
That is my case, Your Lordship.
So that's all. So let the respondent argue tomorrow.
Yes. Yes.
Yes, learned
I will
advocates
submit
for
some
the
judgment
parties are present. Learned advocate for the appellant has concluded his submissions. Let this matter appear on a kalke timings to দেখুন তো on.
Submit some judgment tomorrow.
Anyway, actually, I also don't know whether tomorrow
Achha.
this bench will sit on. Anyway, I'm keeping it tomorrow. কালকে
তাহলে পরে কালকে তো আনসার্টেন আছে।
আপনি বলছেন যে কালকে কটার সময় একটা ইয়ে আছে?
কালকে তো হবে। Tomorrow court will be probably not there.
Tomorrow
not to pass adverse আছে না? Not to adverse.
তাহলে অন্য একটা ডেট দেখুন।
আর
তারপরের উইকের দিকে দেখুন।
তারপরের উইকে।
I can keep it on 1st August also.
As your lordship wishes.
A coming Tuesday. আচ্ছা, let this matter happen.
21 জুলাই।
কিছু নেই আর কিছু
I can.
21/7/2026 at 2 p.m. No, if you are there, if you are not there, you send your junior. Anyway, try to come.
I'll be there, your lordship. I'll submit some judgment on
Mr.
that.
Theory will conclude on that day and you will reply.
Lordship, I'm for item number 6.
Yes, you are for?
Unit of India.
Yes, are you ready today? So you make your submissions. The appellant will start now.
Yes, Lordship.
Yes, item 6. Hey, এটা রেখে দিন।
হ্যাঁ। Shall I start, Your Lordship?
Yes, 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 please.
I am coming to the directly to the factual aspect of the case, which is page 5 of my paper book, Your Lordship. The victim was a young boy. How the
Page 5.
page 5, Your Lordship, of my paper book.
Yes.
How the incident occurred. The accident took place on 16th July 2022 at afternoon hours.
Yes.
The victim on 16 July 2022 morning came to Bajbaj station, which was the nearest and convenient railhead from his house, and boarded up Bajbaj local train and came to Kolkata. He was on his way to Kalighat to visit the Kali temple to offer Kali Puja. Kalighat temple he came, Your Lordship. He was also accompanied by some of his friends. After a brief visit in Kali temple at Kalighat, he was supposed to return to Bajbaj again, and for that he, along with his friends, came to Bresbich station by bus from Kalighat, and after purchasing ticket from Bajbaj up to Bajbaj, from Bresbich up to Bajbaj, they boarded down Bajbaj local from Bresbich station. After visiting the Kali temple, they came to by bus at Bresbich station and boarded down Bajbaj local train from Bresbich station. One Munna Kumar Mahato and the victim boarded in the same train compartment, and other friends boarded adjacent compartment. During the course of the journey, when the train arrived in between Accra and Nangi station at kilometer post number so and so, the victim, who at that point of time stood near the door of the compartment due to overcrowding, lost his balance and fell down from the train and sustained severe head injuries only. What happened after the incident, Your Lordship? Immediately after the accident, some local people rescued him and took him to nearby ESI hospital that was near Bajbaj, Nangi. Immediately after the accident, some local people witnessed and rescued him to nearby ESI hospital, Nangi, in critically injured condition on 16 July 2022 afternoon. Now, considering the gravity of injury, on the same evening, at about 7 p.m., he was taken and admitted to SSKM Hospital, Kolkata, where after being treated, finally expired on 18/7/2022 at 10:15 p.m. Now, after that, subsequently on being officially when this type of incident happened, Your Lordship, as the victim died in the hospital, local PS comes into the picture.
Yes.
On being officially informed, now after the death, the hospital authority informed the Bhavanipur local police station, because Bhavanipur SSKM hospital falls under the jurisdiction of Bhavanipur local police station. Bhavanipur local PS reached the hospital and prepared inquest report in presence of available witness and family members. Subsequently, the dead body was sent for dead body challan and postmortem was done. Now, I have specifically mentioned the co-passenger's name Munna Kumar Mahato in my claim application, and that Munna Kumar Mahato was examined in the tribunal at length.
So this witness.
This witness. I am coming to that, and in this case, the journey ticket was lost at the time of shifting from one hospital to another. In this case, journey ticket was lost.
No, journey ticket was not recovered.
Journey ticket was lost, not recovered. Because the victim first taken by the local people to the ESI hospital, and from there he was taken to SSKM, and during that period his journey ticket was lost. Now, Your Lordship, I am coming to that point. First, I am coming to the.
So
now,
the incident took place on 16/7/2022.
Yes, Your Lordship.
And the person expired on 18/7/2022.
Succumbed to his injuries due to the.
So what was at the time after his death? What was seized from him?
Seized, because inquest was done from the local PS. During seizure, nothing was found.
Okay, but not by the railway police.
No, not the local PS went to the hospital on the next day.
Oh, so inquest conducted by local police.
PS.
So there was no seizure.
And at that, this type of cases, what local PS usually called for, they inquired the matter to the jurisdiction under which the place of occurrence, GRP.
Yes.
In this case, local police send a memo to the place where the person falls. That is in the GRP's jurisdiction, because the accident occurred in the GRP's jurisdiction. But the investigation is done by the local PS since the person has died in the hospital. Now, the document which I have produced, the police document, the general diary entry 740, page 62 of my paper book.
Yes.
This is the extract copy of Baliganj GRPS GD. Because though UD case, as no UD case is registered at GRPS, they have done only the preliminary inquiry. This document was also marked as Exhibit A2 by the tribunal. This is 10:55 AM, 7:40, SI Kundu after the inquiry. What is written? At marginal noted time, SI Biplab Kundu returned back at PS after inquiring an untoward incident. After inquiring untoward incident, noted GD number 731, dated 19/7/2022. 731 GD also I am coming to your lordship. In course of inquiry, I arrived at Accra railway station and asked 3 persons, namely Sheikh Zakir Hussain, son of so and so. Number 2, Mukabil Mondol, 25 years, son of so and so. They are all independent witness. Number 3, Adhir Das, 58, son of so and so. They, during course of inquiry, he examined these 3 persons, and on asking, they stated that on 16th July 2022, at about 4:35 hours afternoon, the incident happened. 1 person aged about 18 years fell on the ground from running down train. They are the independent witness. Down train. Local people rescued and took him to ESI Hospital, Nangi, which is the nearby hospital. On getting information, relatives of the injured person came at ESI Hospital. Then the injured person was identified as Shravan Kumar age so and so. I also contacted his mother. That is written in the GD. And the injured Shravan Kumar was admitted at Trauma Care Center SSKM on 18 July, where he expired. And another GD is also available, 731, which is mentioned in this GD. By this time, I received an IPC from Bhavanipur PS. This GD is the IPC is the report. The Bhavanipur CS asked the local GRP to inform about the matter, what happened. By this time, I received IPC Bhavanipur PS by GD number so and so. One, this is namely Shravan Kumar, a resident of the West Bengal, who was admitted at SSKM Hospital, emergency ward, on 16 July at 7 PM. And expired on 18 July, 10:15 PM. Due to as per medical certificate, death certificate issued from. As per
Which page are you reading?
This is 731, 61 paper book 61.
61, yes.
A1, the marked at exhibit A1. This is also Baliganj GRPS GD. They came to know about of accident from Bhavanipur PS. Bhavanipur PS told the you inquired the matter. Then, as per GD number 62, it is written they inquired the matter from these 3 independent witnesses and came to know that the victim fell down from the train, from the ground. That is GD number 62.
Yes.
So these 3 independent witnesses told that the victim fell down from the train on the ground. They are not also any interested witness. Now, the case was dismissed by the learned tribunal only on the some discrepancies regarding the statement of AW1, the claimant, and the statement of AW2, the young boy who came before this learned tribunal to depose, very young boy. A2, the eyewitness of the incident. Some contradictions was pointed out by the tribunal from the witnesses, what he told at the time of internal inquiry at the RPF, because after the incident, some days after the incident, RPF went to that person's, Munna Kumar Mahato's house to investigate the matter. He made some statement before RPF, and thereafter, at the time of examination, as a witness, in as AW2 in the tribunal below, there are some discrepancy. What is stated before RPF and what is stated on oath. So minor discrepancy regarding the place of occurrence, regarding the timing. On that base, minor discrepancy, the entire case was dismissed. And one more point, Your Lordship, one reason of dismissal is that no railway record was found. No railway memo was there. Why no railway memo is there? Soon after the incident, some local people took the injured victim to the hospital.
Yes.
They don't know, in a bid to save the victim's life, the priority was that the victim to take the hospital. They don't know that the formality that railway person has to be informed. The railway RPF has to be informed. As such, the railway memo was not there. That point was also taken by the learned tribunal, as no information was received by the railway authority. It is not a case of untoward incident. Now, in this context, I am relying on judgment. Oh, sorry. This is the separate case, Your Lordship. Sorry. Judgment গুলো রাখলাম। Yes, Your Lordship. এটা একটু দেবেন একটু। This is the same case where the incident took place. In the this judgment, page 2 of this judgment, Your Lordship, para number 5. In this case, also some friend was traveling with the victim. Now, para number 5, page 2 of this judgment of Honorable Bombay High Court. The first issue which requires consideration, Your Lordship, is the non-reporting of the incident by the friends of deceased to the nearest railway station officials. In this case also, nothing was informed to the railway officials. The deceased and his friends were in the age group of 17 to 18 years, and the deceased having fallen from the train, it is possible that the friends were shocked and frightened, and therefore, instead of informing the station officials, rushed back to the spot of incident and took him to the KEM hospital, because first priority in such cases is to save the injured person. In such cases, therefore, it is important to consider other materials and circumstances to ascertain whether any such incident has actually happened. So in this case, the High Court considers, Honorable High Court, other evidence, the inquest report, the postmortem report. So from the other evidence, it was established that the victim was running, traveled from any running train, and untoward incident happened. In this case also, Your Lordship, from the police investigation and from the statement of 3 independent witnesses, it is clear that they saw the victim to fell down from the running train on the ground. And as they were the local resident, they did not know about the procedure, they took the victim to the hospital. And as such, the incident was not reported to the railway authorities. And regarding loss of ticket, Your Lordship, there is recently one judgment was passed by Honorable Justice Ananya Bandyopadhyay. In this case also, ticket was lost. Same incident, ticket was lost during. So in this case, it was held by the Honorable High Court that the victim died in an untoward incident, the ticket may be lost. I am coming to that also. This judgment kindly give. That judgment is pertaining to the loss of ticket. Ticket was not found. So on that point, I am relying on another judgment, Your Lordship, also. That is Gujarat Ahmedabad High Court, dated very recent judgment, 5th May 2026. Now, in this case, what the same thing happens, the ticket was lost. And in this case, also the co-passenger who saw the victim to purchase railway ticket. I am coming to that. That was also my case. The Munna Mahato saw the victim. So in this, kindly give this judgment to Your Lordship. Now, this judgment This judgment, your lordship, page 2, para number 6. What appears from the impugned judgment that learned tribunal to meet with the contention that deceased was not a bona fide passenger, as no ticket was found from the place of incident. Here, same case, no ticket was found. Or clothes of the deceased person of the. He referred to judgment High Court Madras in case of Ishwari versus Union of India, your lordship, and famous judgment in the case of Union of India versus Rina Devi, your lordship already knows. And third page, paragraph number 14, High Court Madras held in the case of Ishwari versus Union of India, and page number reported in TSC 329. In para number 8, relied on apex court judgment of Gopal Krishanji Ketkar, and in the judgment of para 11 reads as follows. We are quite conscious of the position of law that is provided in section 106 of the Evidence Act. If a fact is within the special knowledge of a person, the burden of proving such fact is on that person, and as provided in the illustration B of the section. If a person is charged with traveling on a railway without ticket, that burden of proving that he had a ticket is upon him. But such principle is not applicable to a case of a dead person whose dead body was found near the railway track and whose body was taken in custody of the railway police. In such a situation, it is the duty of the railway authority to first give evidence that he was without a valid ticket. When the owner shifts upon the claimants to prove that he was a bona fide passenger having a valid ticket. Now, in this case, your lordship, from the evidence of the Munna Mahato, it is clear that he saw the, I am coming to that evidence, he saw the victim to purchase ticket from Bresbridge railway station. That I am coming. In this case, as no person on behalf of railway has given any such evidence, not has any person come forward to disclose that articles were found with the victim, we conclude that the initial burden of proving such fact had not been discharged. We cannot lose sight of the fact that one is not entitled to enter even the platform of a railway station without having a valid platform ticket, and one takes the risk of criminal prosecution by boarding a train without ticket. In such circumstances, in the absence of any evidence of railway authority asserting absence of a valid ticket, we are of the opinion there is no just reason for totally discarding the evidence of PW1, the mother of the victim, who deposed and asserted that it was she who purchased the ticket for son and handed over same to him and saw him off in the railway station. In this case also, the Munna Mahato saw the victim to went to the ticket counter to purchase the ticket. From the cross-examination, it is crystal clear. Munna Mahato's cross-examination, it is crystal clear that he saw the victim went to the ticket counter when he was returning with him from Bresbridge. After that, the ticket was lost. We have already mentioned that in cross-examination, no suggestion was even given to her denying the
From which train? That is
down Bajbaj locally. And there, after the Rina Devi case was discussed, and after that, so many cases of Supreme Court cases was discussed in this judgment, from which it is established that even if the ticket was lost, the initial burden is discharged by the, in that case, the initial burden has to be discharged by the railway authority, because the principle of 106 of Evidence Act will not apply in case of a dead person. Now, Mahato cross. Yes. So from the cross-examination, why the case is one most important, I forget to mention, your lordship, in the DRM report, they have filed the DRM report. Respondent himself produced a document. DRM report is in this case, your lordship, collective document, page 14 to 70. Total set is DRM report, and the total set is marked at exhibit R1. In this DRM report, your lordship, page 42, they have produced page 42 of my paper book, your lordship.
Yes, 42. Yes, last column, last paragraph. Right-hand column, 42.
Page 42. Now,
right-hand column.
Yes, this is the annexure A.
Yes.
This is continuing. Annexure A, your lordship, please go to page 39, your lordship, paper book. Yes, page 39, page 40, page 41, and page 42. This is the detailed accident report, your lordship. This detailed accident report they have produced with their investigation report, which is collectively marked. This is the part and parcel of DRM report itself. Page number 39, the place of accident at kilometer post number between Accra and Nangi. Detailed accident report. Name of the person who took the victim to the hospital.
Page 39.
Page 39. This is the total set. Page 39.
Actually, you
to page,
see, in this case,
Yes,
there
Your
are witnesses. Only dispute is valid ticket.
ticket was not found in this case, Your Lordship.
Yes, that is the only question.
The only question.
And the witnesses who have examined, did he state that they purchased ticket?
Yes. In the cross-examination, it comes.
No,
He-
question is because suppose friends are going from one station to other station.
Yes.
In the group, they will purchase the ticket.
Yes.
Either individually or one person will purchase for all.
Yes, in this case, he at the time of cross-examination, he categorically told that the victim was going to the ticket counter of Brisbane railway station. That point was not denied.
Yes, victim was.
The witness Munna Mahato at the time of cross-examination before the tribunal, he categorically deposed that he saw.
Let us come to that paragraph.
Cross-examination. Cross-examination, Munna Mahato.
So how many? Two witnesses were examined.
Two witnesses.
One is the eyewitness.
One is the claimant and one is the eyewitness.
Only thing is this: where is the deposition regarding that he saw?
Deposition is entirely typed in the judgment itself also.
No, page.
Page.
So
Munna Mahato. This is page 76, Your Lordship, of the paper book.
So it is not index.
Page,
Shown in the index.
Look at the index, page 76.
Just-
Yes. In the index, it is there. Photocopy of cross-examination. Page
Yes.
75 to 77.
Yes.
This is page 76.
Yes. Oh, at Brisbane, the deceased went to the ticket counter to purchase his ticket, but I did not see him purchasing ticket.
Yes. That may be quite possible. I am standing in the platform, long platform. I saw somebody to went to the ticket counter. That is sufficient that he was purchasing the ticket.
Okay. To the ticket to purchase his ticket. At Brisbane, the deceased went to the ticket counter to purchase his ticket. Did not see him purchasing ticket. Okay. That means he was sent to purchase the ticket.
Yes.
Anyway, the moment he purchases ticket will not be given to or distributed. It will be kept with him.
Kept with himself, with the victim.
Earlier, the tickets were on the basis of individual heads. 1, 2, 3, 4, 5.
Yes.
Now, in particular, one ticket is
One ticket, yes,
reflected.
that ticket was lost, and the co-passenger's ticket was. It is not possible in cases because the claim application is lodged after many years of the incident. The co-passenger usually did not preserve their ticket. If the co-passenger ticket was
No,
seized,
actually, you see, he is not saying that he went to purchase ticket and get the ticket to me.
No.
Because he purchased.
Yes.
So definitely he will keep it with
Yes,
him.
Your Lordship. Yes, Your Lordship.
And
That-
sell some station.
Station. So the initial burden, as per the Rina Devi case, is well discharged. That
Anyway, you will be able to complete today.
yes, as Your Lordship, I can continue on that day also.
Yes. Who is appearing?
you please.
Respondent?
That virtually.
Yes, Lordship.
So you make your submission on the next day?
Yes, I can also
Okay,
continue.
Lordship. Okay,
Yes.
Lordship.
Order. Learned advocates for the appellant submits. Stop. The argument on behalf of the appellant is treated to be concluded. Fix. দেখুন কবে? 27/7/2026 for argument of learned advocate for the respondent at 3 p.m. চারটের মধ্যে কমপ্লিট হবে কি? না, ওনার না, রেসপন্ডেন্ট।
21 তারিখে হবে না, 21শে জুলাই? আর আচ্ছা,
21/7/2026 at 2 p.m.
yes, Your Lordship, grateful.
Careful.
Thereafter, you submit your written notes.
Grateful to Your Lordship.
Yes.
বিজয় সিনহা একই আছে দুটো।
Yes, Mr. Chatterjee, you have to conclude.
Yes. Lord, I'm sure, my Lord, your Lordship remembers it. But
You have
just to-
referred to the different orders of the court,
my Lord,
different orders passed by the executing court, different undertakings on
my Lord. My Lord
This-
takes up the list of dates. I think if I read through it, everything will come back to your Lordship. Lord, plaintiff's appeal in a suit for declaration of title and praying that a particular execution case by which Lord, the sale had happened in favor of Mr. Mukherjee's predecessor, that is void and a of fraud. This is the matter about Lord. My property loan was taken. Looks to comes to a list of dates, Lord.
list of dates to din.
Then I don't have to, Lord. It will be easier for your Lordship, Lord, to recollect. না লিস্ট অফ ডেটসটা আলাদা করে আছে স্পাইরাল বাইন্ডিংটা বোধহয় বই এগুলো আরেকটা কপি দিয়ে Lord,
You have also filed a compilation also.
yes Lord, a compilation পেয়েছো
Yes. Yes,
Lord,
I have
kindly
recorded
put the
also.
first month. The first
Yes.
date is 18th of September.
So you have referred on the earlier occasion, terms of settlement,
Yes,
104A,
yes,
then first execution case, second execution case
Yes.
within span of 21 days, second execution case was filed,
yes.
which was not within the knowledge.
So grateful,
Then degree holder purchased the property.
so grateful. There was
These were already,
degree holder himself put it into sale and himself purchased it.
yes, these were your submissions.
And these were these are part of fact as well as my submission.
Yes.
And beloved, your Lordship had seen, beloved, I had also referred to the provision. And why, beloved, it's a fraud? I was trying to, beloved, all these facts together, beloved, constitute a fraud. First of all, beloved, your Lordship would also remember, I had told your Lordship about possession. That they had said, beloved, that the bailiff had given them possession, the degree holder in the earlier suit. But they themselves admitted that they were never in possession in this premises.
That is the purchasers.
Purchasers as well as below
That is their predecessor.
they have admitted that they were
They
never
were not in possession.
never in possession. Then below whatever I have said, there was a local inspection. In that local inspection, Milord, everything had come out. I had placed it before your Lordship, but just to Milord remind your Lordship, kindly takes up Milord the paper book. The কোন পাতায় আছে local inspection রিপোর্টটা as usual জানি না just gives me a second, I'll find it. একটু কাজ করো আর চেঞ্জই হলো না কোনোদিন যেরকম ছিল ঠিক সেই রকমই রয়ে গেছে একটু যে ভরসা করতে পারবো তাও হলো just give me 2 minutes time and I'm sorry for it's my mistake. Lord, if your Lordship takes up the compilation once.
The compilation টা দিন একটু
Lord, kindly turns to 58A. There was a translation
58.
A.
Yes.
Lord, your lordship will find, I being appointed as a commissioner in the aforesaid suit, the learned lawyer on behalf of the opposite party not being appointed till this day, by giving notice duly to the learned lawyer on behalf of the plaintiff only as per the identification made by the plaintiff, inspected the place for the said commission at 11 a.m. and upon inspection of the point directed in the writ in presence of the local persons and submitting the report to the following effect. On inspection regarding the first point, it is seen that on disputed land in Dag number 902, the dwelling house of the plaintiff is there.
Yes.
So that's the first, my lord, the report of the, my lord, the commissioner. The detailed particulars: one kitchen, 2 bedroom, hen poultry. On inspection on second point, it is seen that numbers such and such are adjoining to each other in compact with the land in all the said Dagor. On inspection of third point, it is seen that along the outer boundary Dag, there are shuli, kacha tree, date palm, jamstick. On inspection of the fourth point, it is seen that out of the said কোডটা কি ওটা বাংলায় কিছু একটা লিখেছে
There are shuli, kacha tree,
হ্যাঁ
palm tree, drumstick.
চতুর্থ পয়েন্টের কম্প্যাক্ট and the A pact pillar is basically compact. If your lordship sees below the Bengali version at 59, my lord will see, my lord,
কোন পয়েন্টসের
হ্যাঁ
পরি
চতুর্থ
দর্শনে
পয়েন্টের পাবলিকের দেয়া জায়গাতে যাতায়াতের বাদীর উক্ত একট or
page
compact.
59.
Yes, Philo. That's the Bengali version. And that's the better version in my respectful submission. The translation did not will not.
Anyway,
And it says, Milord, that what I'm trying to say is, Milord, that I am in possession. It comes out from the local inspection itself in actual physical possession. So whatever was being done, Milord, was being done
plaintiff was in physical possession.
actual physical possession.
This is the commissioner's report.
Yes, Milord. And they were always trying to say, the defendants, the original defendants, that they had taken possession through the bailiff, which is not correct. It is nobody's case, Milord, that I was thrown out of possession and thereafter I have come back into possession. Nobody's case. সেটা আমি দেখাচ্ছি. Now, my lord, my lord's kind pleasure to come back to the written statement once of both parties, which are a little relevant. Just the relevant portions, my lord, I'll show your lordship, not the entire thing. Just to, my lord, for the sake of recollection, what was their case? Lord, if your lordship starts from এক্ষুনি দাগ দেওয়া ছিল, এক্ষুনি দাগ দেওয়া, হ্যাঁ, 29 and takes up plot 29A. This is the additional written statement, my lord, of defendant number 3, that is Mr. Mukherjee's claim. My lord, kindly got it?
29A.
Yes.
Yes.
All the statements made by way of amendment of the plain past are being misconception of law and fact. Even if any execution of degree is dismissed on part satisfaction for realization of the remaining sum, execution of degree is lawful. There being attachment of judgment in the original suit and there being no attachment in the execution of degree and execution case is not at all unlawful, and the said auction, there being no other attachment in execution of degree. Ramchandra Mukhopadhyay, being without making any further attachment, had lawful right to put the case on execution of degree until the payment is made. The auction which was held in execution, Atum. This is their additional written statement. Porchas, your Lordship has seen, the porcha is in my name. All the record of rights, everything till today is in my name. That's never been changed. Now, what I was trying to impress upon your Lordship was ওই জায়গাটাতে বলেতে যেখানে ও বলেছে যে আমরা প্রদর্শনে আছি সেই জায়গাটা একবার দেখিয়ে দিই, তারপরে আর ফ্যাক্টটা বন্ধ করে দেব। Lord, I'm not troubling your Lordship with the fact that there were 4 installments. Within that 4 installments, Lord, that the money was paid. He had taken, Lord, about 300 rupees.
Whether in second appeal this can be gone into or not.
Lord,
That is a different issue, all this detailed fact.
Of record.
Whatever you can submit on the points of law,
Absolutely.
that should be
Lord, what I was saying is, the trial judge did not even look into this part. So it is a question where, my lord, there is appreciation of evidence. When does, my lord, a second appellate court have a right? When, my lord, the court has gone on wrong appreciation of evidence, or on the basis of no evidence, or on the basis of, my lord,
non-appreciation.
Perversity. When is perversity? When there is evidence on record, but the learned judge doesn't get into that evidence at all. No, I'm purely on a question of law before your Lordship as to how the sale could have happened. Lord, there was a money degree against me. There is no dispute on that. What was the money degree? The money degree was for 700 and odd. This was brought down to 400, Lord, by way of a compromise. The numbers.
So these documents are there.
All these
before the trial court.
All these documents are there before the trial court. Now, the amount of money, my lord, may my lord, vary. X was the amount. It was brought down by way of a compromise degree. Then there were 4 installments granted by the courts below, by the court below. Once that installment was granted, my lord, Lordship goes back to the, my lord, when the submissions were being made as to when the installments were to be paid. They filed, my lord, once the execution was finished with that order, my lord, it was disposed of. The second execution is filed within 21 days.
That is premature.
And why fraud? Because the person, my lord, who is the, my lord, judgment debtor was not even given notice of that sale. There is nothing on record to show that there was notice of that sale. Why another case of fraud? Because the degree holder himself goes and purchases the property by a few hundred rupees or something and sells my learned senior friend's client for 1 lakh. This is the fraud happening.
35,000.
This is the fraud which happens and which is on the face of record back. Now, kindly have a look at why I am saying it's perversity. Have a look at the judgments once. Judgment to that, right? Kindly consider the trial court's judgment. Judgment is that. Why I'm saying it's bad in law? I will not trouble your Lordship with the entire why perversity. It's only that I will show your Lordship. All these
Page 38.
Yes. No, kindly first turns to the no, next. Kindly turns to, my lord, the trial court's judgment first.
Yes, page 1.
Page 1. Kindly comes down. Your Lordship would find all these facts are there, written, recorded by the trial judge. Kindly comes down and sees, my lord, issue number 2 at page 10. Allow me, my lord, to place this before your lordship. The perversity your lordship will find out from there itself. I don't think I'll even have to, my lord, argue on that. The original plaintiff states that the cause of action to institute the present suit arose on and from 7th of April 1988 when he, or the first time, learned that the predecessor of the defendant numbers 1 and 2, namely Ramchandra Mukhopadhyay, have obtained an illegal sales certificate in his favor. In respect, my lord, here may I just remind your lordship, there is no deed before your lordship. It is only on the basis of the sales certificate. There is no deed which is there, my lord, in favor of my learned
And
senior
no
friend.
registration.
No registration. Nothing. In favor of, my lord, Mr. Mukherjee's predecessor.
Just a declaration,
Just a sales certificate.
certificate,
That's
and so no registration.
No registration. In his favor in respect of the suit scheduled properties without any notice or knowledge of the plaintiff, and when the defendant number 3 threatened to dispossess him from the suit scheduled properties on the basis of a bainanama executed by the defendant number 1 in his favor in respect of the suit scheduled properties. The contesting defendant, though formally raised objection against the claims of cause of action of the plaintiff, but however no specific argument was forwarded on this point, the issue is decided in favor of the plaintiff. So maintainability of the suit, my lord, was decided in favor of the plaintiff. Then kindly comes down. I'm not troubling your lordship. My lord, your lordship will see the money suits at page 11. It's been recorded. Then lordship sees 1962, my lord, in the latter part of that paragraph. Then money execution case number 448, 1963 was initiated in respect of the degree passed in the above money suit. These are all there, my lord, in your lordship's list of dates. Not troubling your lordship. Sees below 950, including interest as satisfaction or degree. That was below recorded as well. All the facts below are recorded by the learned judge, but kindly sees the appreciation.
This is receipt of 950.
Yes, below. They have taken
1960 to 950 was
a lot of money. And my lord, your lordship will find thereafter my Mr. Mukherjee's predecessors have taken the entire money from me. Entire money from me he has taken, and that's admitted and proved before your lordship. Then, my lord, exhibit C is recorded. Comes to, my lord, the next page, the certified copy of the degree in money suit in page 14.
page 14.
Second line. The certified copy of the degree passed in money suit number such and such as filed by the defendants in this case reflects that degree was passed for rupees such and such on such and such. As discussed before, the plaintiff of money suit number such and such had initiated money execution case number 448 of 1963 initially, which for reason unclear to this court was dismissed on part satisfaction of rupees 400. Accordingly, from the certified copy of the execution application registered in money execution number such and such, it appears that the same was instituted for balance amount of 362. After initial satisfaction of 400, and the schedule of the properties mentioned in the said execution application initiated by Dhirendranath Boiddo is similar to the properties mentioned in the schedule of the title suit. This is a specific finding. As discussed earlier, the said properties were already under attachment during the proceedings of money suit number such and such. Now, my lord, with a lot of respect, if the execution is over, may I ask this question to myself, does the attachment stay? The first thing, my lord, would hit your lordship, my lord, that this is the perversity recorded in the order itself.
If the execution is over, attachment either
Cannot stay.
it will be withdrawn or followed by sale.
Exactly.
Followed by sale.
It didn't happen then. It didn't happen then. Then sees how, my lord, he in a lot of ways makes up for it. From the documents marked Exhibit F, it further appears that while proceedings with such and such, this is the next one, my lord, instituted for recovery of balance amount of 362 from judgment debtor Dhirendranath Boiddo, after money execution number such and such was dismissed on part satisfaction, out of total decreed amount of 755, this court issued sale certificate dated such and such in favor of degree holder Ramchandra Mukhopadhyay. After his engaged advocate acting on behalf purchased the properties mentioned therein in public auction sale by paying money decided. Again, my lord, this is a recorded fact which is recorded by the judge that he was the only one, my lord, who was there in the auction, if there was any. Thereafter, by order dated Sansad, this court further affirmed the possession of the properties in respect of which sale certificate was issued after public auction was properly delivered in favor of Ramchandra Mukhopadhyay. Thus, there remains no doubt that the court, following the compromise degree for the sum of 755 to be paid by defendant Dhirendranath to plaintiff Ramchandra in 4 yearly installments as mentioned in the compromise petition, had initially dismissed money execution on part satisfaction, and thereafter money execution number 6364 was again initiated for balance amount remaining unpaid, and this time the court directed auction sale of properties previously attached at the time of money suit number 59 of 62. The degree holder Ramchandra Mukhopadhyay appears to have duly purchased the properties so attached. Suit scheduled property of this case at public auction sale, and accordingly, sale certificate was issued in his favor and possession of property so purchased was delivered. Kindly marks this and sees.
No, actually, the trial court is going by the record. What is there in the record?
Absolutely, but
Trial court has gone by the record.
But my lord, the inspection report is also on record.
On the physical verification.
My lord, on physical verification is on record, which
The
is
question is,
ordered
what was
by
the
the
plea?
tribunal.
Whether was it your case that the entire proceedings was vitiated by fraud? That is-
Absolutely, completely.
because court has gone by the record.
Absolutely, my lord. This is where I say the perversity comes into play. My absolute case before your lordship is, my lord, that this sale that happened behind my back.
Because you see, the report
my
was
property.
submitted, the
My lord.
possession handed over.
My lord, but then he did not, my lord, take into consideration the physical verification report, which is ordered by the trial court himself. Sees how it goes on, my lord. That is the fraud on face of it. My lord, I'll show your lordship a judgment which says, if I was to be a party to a suit, in this case a sale, and I was not made a party to that, my lord, the entire process is a nullity. Entire process is a nullity. It's a nullity. Why?
That execution case was ex parte case.
My lord.
That attachment.
My lord.
So was that 2 years? That was not 2 years old.
Could not have been. But once the sale happens, my lord.
Yes.
Once the sale happens, and if the degree holder purchases it,
yes.
then an order 21 rule 72 has to come into play.
Yes. So now let us see that.
Okay.
Okay. Just a minute. So it's factually, it is the degree holder which purchased the property.
Yes.
Let us see that order 21.
Yes, order 21, rule 72(3).
Yes.
Where a degree holder purchases by himself or through another person without such permission, the court may, if it thinks fit, on the application of the judgment debtor or any other person whose interests are affected by the sale, by order set aside the sale, and the costs of such application and order, and any deficiency of price which may happen or resale, and all expenses attending to it shall be paid by the degree holder. So this is what I have invoked. This is what I have invoked. The court says I should have gone there. I'll come to that. I should have invoked this. Then what else have I invoked? May I ask this question to myself?
That is whether suit is maintainable.
Yes.
For this purpose.
I bow down, my lord. I bow down.
That is the question of law.
Absolutely. And whether, what is order 21 rule 72(3)? It's an enabling provision. Where does order 21 rule 73 come into play?
When the execution proceedings are still pending.
Bow down, my lord.
But here it is disposed.
And I'll show again a Supreme Court decision, my lord, which says if it's a question of fraud, I can challenge it anywhere, even by filing a suit. I'd shown your lordship on the last occasion, 99-4, if I'm not
Anyway,
mistaken.
so
94-1 SCC page 1.
Yes, you advance your arguments on
Yes.
these issues.
Yes, my lord. This is the
Instead of
that's
that
the substantial
execution
question.
case, whether how much you have paid and not, instead
My
of
lord.
going into all those things.
My lord, absolutely. Then kindly comes down how the learned judge has dealt with it. Turns to page 16. I'm not placing the entire, my lord, would be wasting my lord's time. In this backdrop, the instant suit, my lord, kindly got this? Instituted by Dhirendranath, judgment debtor such and such, Atto claiming that no attachment of his properties existed after money execution number such and such was dismissed on part satisfaction, and thus any order of auction of the properties in subsequent such and such without issuing any notice upon him by obtaining proper sales certificate is not binding upon him, as the same is illegal, void, and inoperative. Then, in order to establish the plain case, your lordship comes down. Then these arguments go on, my lord. I'm not troubling your lordship with what the learned advocates have said. Defend number 3 advocate, your lordship comes down, my lord. Turns to, my lord, page 21. Again, your lordship may, my lord, the last part of 21. It is admitted by both the parties that degree was passed in MS number such and such in favor of Ramchandra against Dhirendranath. Certified copy of degree filed by the defendant number 3 in this case reflects that degree was passed for rupees 7 crore. It's been repeated again, so I'm again not troubling your lordship with all. All this has been, my lord, recorded by the learned trial judge. It is also admitted that the parties mentioned in the suit, and it is admitted by the parties that on failure to make payment, admissions recorded. Now, plaintiff of this case, Dhirendranath himself, claimed that they had paid rupees 950 to Lokhi Prasad Mukhopadhyay, son of Ramchandra Mukhopadhyay, the original defendant number 1 of this case, substituted by his legal heirs. After the death of Ramchandra and receipt dated 5th Falgun such and such was validly issued, the defendant number 3 denied genuineness of such receipt. It's his denial. On calculating backwards in terms of English calendar, it appears that the said receipt was issued in the year 73-74. From the certified copies brought on record by the parties, it appears that money execution was dismissed on part satisfaction on 64. From the said certified copies, it further transpires that the second execution case being such and such was instituted on 27th of April 2064 and sale certificate was issued on 3rd February 65 and possession of the properties were delivered in favor of the degree holder on such and such delivery of possession was confirmed by order dated such and such. This is the perversity on the face of it. Kindly sees. In such circumstances,
Perversity means, you see, whatever is there in the record,
yes,
just consider that.
Finding on that.
Yes.
He is keeping an eye on that part of the fact. There is another fact which is on record.
That is a local inspection.
Yes. That this fact never happened. It's nothing but a paper transaction. And which is done behind my to his son Lokhi Prasad Mukhopadhyay as per degree of MS number Sansaj after dismissal of Sansaj and before institution of Sansaj does not tally with the documents filed by the plaintiff Dhirendranath himself in this suit. Obviously, receipt issued in the year 73 could not have been issued after dismissal of Sansaj. I do something behind my back and then takes money from me as well later. Obviously, or whenever it is, the receipt is issued at that point of time, but taking of money is admitted. And if it is going to be disputed, it has to be disputed by him, the person who has given the receipt. And he has to come and show, my lord, that I have.
He has to be examined.
My lord, not defendant number 3. Defendant number 3 had got nothing to do, my lord, with any fact which had happened earlier. He was not born even at that point of time. Obviously, receipt issued in the year 73-74 could not have been issued after dismissal of such and such and before institution of money execution atto. Moreover, from the said receipt filed by the plaintiff, it is also not clear if the said amount of 950 was paid towards satisfaction of the degreeable amount of money suit number such and such, and it is not specifically stated in the said receipt. Moreover, no explanation given by the learned advocate for the plaintiff as to why 950 was paid towards satisfaction of digital amount of 755. Maybe, my lord, the interest they wanted to take, we don't know, was already dismissed on part satisfaction of 400. No detailed explanation was also given as to why and on the basis of what calculation 950 was paid to Lokhi Prasad Mukhopadhyay, ignoring the heirs of Ramchandra, when the plaintiff Dhirendra knew that Ramchandra had other heirs. The plaintiffs have also not disclosed in their plaint about the date of death of Ramchandra, so as to enable this court to understand if in the year 1973-74, Lokhi Prasad was legally capable to receive money due to his father. Thus, the claims of the plaintiffs about Dhirendra.
So this Lokhi Prasad was the petitioner.
Yes, my lord.
In the execution case.
My lord. Lokhi Prasad.
Who was the executioner?
Execution was, my lord, Ramchandra.
Okay. Petitioner, decree holder.
Yes.
So
the plaintiffs have also not disclosed
amount was paid to whom? Ramchandra.
In the estate of Ramchandra.
Okay.
One of his sons, he came and took the money from me.
And executed the terms of settlement.
No, terms of settlement was earlier, my lord. Terms of settlement was entered into by Ramchandra during the time of the degree of the suit.
That is why the execution case was filed out.
That is why the execution was filed by.
Again another payment and settlement.
Another payment. And now the third payment has come in. My lord, there are 3 payments.
So during Ramchandra's tenure, any amount was received for settlement by him.
By him.
And
that's the 300, 770.
Yes.
Then there was 4 installments given.
Yes.
Everything was received by him.
The latest payment was received by whom? This Lokhi Prasad.
Yes.
So only one portion was received by Lokhi Prasad.
Yes. May have been, my lord. But the others were received by Ramchandra.
Ramchandra himself.
That is why the execution was dismissed on part satisfaction. Because they had given me time to pay.
Then again reinstituted.
Then he again on the 21st day, he instituted, my lord, the second execution. When I had the time to pay, his execution would have come into play, my lord, nicely if I had in some way, my lord, defaulted, my lord, after the money was due. That would have been his best possible case. Even then, I would say, my lord, if you are selling my property, you have to give me notice.
So that is the provision which you.
Yes.
No, that is the remedial provision.
Exactly, and this is that remedial suit. This is that remedial suit. The learned judge has said, I'll show your lordship later, I should have invoked this provision, but I'm invoking this provision. How would I invoke it any other way? It can't go, my lord, back to somewhere else. It can't. I have to file a suit. That's why that 94 decision is very important. Then, my lord, even at the risk of repetition, it is necessary to further point out that though the plaintiffs of this suit, such and such, filed a receipt and claim such and such for deposed with the defendant number 1 of this suit being one of the heirs of Ramchandra, as full satisfaction of the degree passed, but however it appears that the said receipt was never placed in any proceeding in between the parties previously or brought below 73 below, there was nothing. As required under the provisions of Order 21, Rule 2, Sub-Rule 3, in absence of any certification or satisfaction of the degreeable amount by the court allegedly paid out of court to a representative of the degree holder, such receipt of 950 cannot be treated as proper satisfaction of the degree in such and such, unless the adjustment of paid is made under Order 21, Rule 1, Code of Civil Procedure by the judgment debtor, and the same is certified by such and such. The same cannot be recorded in view of Sub-Rule 2A. Now is the important part. Thus, in view of the above detailed discussions, it appears that the plaintiffs have failed to establish that they had satisfactorily repaid entire degreeable amount in favor of the degree holder Ramchandra Mukhopadhyay or his heirs, and thus Ramchandra had no legally enforceable reason to institute subsequent such and such after such and such was dismissed on part satisfaction of the degree. Milord, may I ask this question to myself? While coming to this, Milord, finding, did the learned judge even refer to the 4 installments granted?
Yes.
With a lot of respect to the learned trial, we have a lot of respect for them. He had to come to a finding. that his second execution case was ripe.
No, just like you see
Ah.
under Order 21,
Yes.
Rule 101,
Yes.
any questions to be determined has
Yes.
to be by this petition
Absolutely.
and not by a separate suit.
The only exception is when it's a question of fraud.
No. Order
Well, that
21,
is
Rule
when-
101.
Yes. When
So
when-
is that applicable? Is that bar
with
under
a lot
that
of respect,
provision?
Lord, in my respect, to
Because you
submission,
see,
I know.
so for 101 is concerned, it is express bar.
Bow down.
So for
complete-
that,
Lord, kindly turns to 101 once.
Order 21, Rule 101.
Kindly turns to it.
So here it is an absolute bar.
Absolutely, it's a bar. But when? When is it a bar? All questions, including questions relating to right, title, or interest in the property, arising between the parties to a proceeding on an application under Rule 97 or 99, or their representatives, and relevant to the adjudication of the application, shall be determined by the court dealing with the application and not by a separate suit. For this purpose, the court shall, notwithstanding anything to the contrary contained in any other law for the time being in force, be deemed to have jurisdiction to decide such questions.
So this is a bar under section
Yes, but
100.
when the execution is live,
Yes.
when the execution is live or it has been instituted,
So that is what, no, on the other hand, you see, Rule 106 does not provide any express bar.
no.
The
it
second
doesn't.
thing is this execution has come to an end.
Come to an end. So Order 21 Milord will come into play only when any proceeding under Order 21 is pending. And I'll show that judgment, Milord, even in a collateral proceeding. Even in a collateral proceeding, Milord, I can go and show, Milord, that was a question of nullity. Milord, Order 21, Rule 101, in my respectful submission, is something very different from what we are here today. Milord, where a suit has been decreed, somebody is claiming a right over that property.
So you are borrowing that principle
Yes, Milord, I am.
and the elements and the ground of fraud, that principles and the ground of fraud, to
Absolutely on the
institute
ground.
this suit.
Yes. And the enabling provision of Order 21, Rule 72(3). Where, my lord, the judgment debtor, rather the degree holder, buys the property. That's the enabling provision.
Order 21, Rule 72. No holder of a decree in execution of which property is sold shall, without the express permission of the court, bid for or purchase the property.
And if done, then it's 3.
It is
3. Sub-rule 3. So this is where, my lord, the fraud on court forgets about me. This provision, in my respectful submission, was probably not even looked into. Perversity comes in there.
so it was not argued before the court.
It's a question of law, my lord, where I can argue even for the first time before the Supreme Court. And even if I have not argued, the law is law. This is not a point taken. This is not factual. This is legal. So even if your lordship feels it's not argued, 77 Supreme Court, page 5. If it's a pure question of law, goes to the root of the matter, my lord, I can argue it even before the Supreme Court. Bit 77 Supreme Court. Page
AIN
5.
1977
Supreme Court, page 5.
Page 5.
If it's a question of law with no facts involved, I can argue it for the first time before the Supreme Court.
Anyway, you don't have much to argue about facts.
Yes.
You can come to the
Yes,
provisions
yeah,
of law.
just findings, a little bit of finding, and then. দেখাবো আমি, I know, I'll come to it one by one. Why are you in a hurry? Then, Milord, kindly turns to page 26. Skips the first part. It's about, Milord, recovery of the balance due. Second paragraph. Regarding the points raised by the learned advocate for the plaintiffs about the properties not being attached afresh in proceeding of money execution case number 63 or 64 before auction, as properties attached at the time of pendency of money suit number such had ceased to be attached after dismissal of money execution number such, be it mentioned that it is not the lookout of this court in this court while hearing a title suit if all procedures are laid down in the statute were followed by the executing court while dealing with money execution case number. But there can't be more instances of perversity. I am saying this suit, I am saying, Milord, that execution case is a matter of fraud. The court will not see. Milord, that means the court hasn't looked into the evidence which is on record. Perversity again, second appeal, Milord, comes into play again. Then is not performing the duty of hearing an appeal after 24 years against the orders passed by the executing court in Sansaj. Moreover, the plaintiffs have also not produced certified copies of the entire order sheet of money suit number Sansaj before this court for perusal. It is necessary to mention herein that it has been specifically stated in Order 21 Rule 92 that when no application is made under 89, 90 or 91 or where such applications is being made and disallowed, the court shall make an order confirming sale. Thereafter, sale shall become absolute. Doesn't look into 72 at all. Our case, Milord, is on 72. It is not on. Malord?
Specific provision with
Yes,
ex party.
exactly. Our case is not on 89. Looks to 89 once.
Yes.
89, Milord, is where sale needs to be set aside when the money is paid, and 90, Milord, is on fraud. And I am saying, Milord, the fraud is happening on the face of record in terms of 72. There is a bar under 72. I don't have to even get there. When it's a question of nullity, Milord, I don't even have to be there. I'll give you a lot of 2 judgments on that. Just gives me a second. I'll Inika 67 Supreme Court 1269 67 Supreme Court 1269 R 2025 SEC Online Supreme Court 2360. On the next email, I'll show you lots of the judgments. I'll send them as well. 2360. Then, Milord, from the documents available in the record, it appears that auction sale and money execution case number Sansach was ordered against judgment debtor Dhirendranath Boiddo, who was a defendant of MS number Sansach. The present suit challenging the said auction sale and sale certificate issued in favor of Ramchandra was also instituted by Dhirendranath after 24 years. As per provisions laid down in Order 21, Rule 92(3), no suit to set aside an order made by this rule shall be brought by a person against whom such order is made. From the certified copies filed by the defendant number 3, it appears that not only did the executing court in Sansaj issue sale certificate.
Page that is?
Malad?
Which page are you reading?
28.
Yes, 28.
28.
Yes.
It appears that, first line, from the certified copies filed by defendant number 3, it appears that not only did the executing court in money execution number 63 issued sale certificate against Dhirendranath, but also confirmed the said sale by order dated Sansaj, stating that possession of the properties purchased through auction sale was delivered to the sale certificate holder Ramchandra. In such circumstances, Dhirendranath Boiddo could not have instituted this suit in the year 88 as he was barred under Order 21 Rule 92(3). Well, kindly turns to Order 21 Rule 92(3). Please, my lord, Order 21, Rule 92.
Yes.
Where no application is made under Rule 89, 90, or 91, or where such application is made and disallowed, the court shall make an order confirming the sale, and thereupon the sale shall become absolute. Provided that where any property is sold in execution of a degree pending the final disposal of any claim to or any objection to the attachment of such property, court shall not confirm such sale until the final disposal of such claim or objection. Where such application is made and allowed, and where the case of an application under 89, the deposit required by that rule is made within ATO, is found to be deficient owing to any clerical or arithmetical mistake on the part of the depositor, has been made good within such time as may be fixed by the court shall make an order setting aside the sale. Provided that no order shall be made unless notice of the application has been given to all persons affected thereby. Then, provided further that the depositor of your lordship need not. Then, no suit to set aside an order made under this rule shall be brought by any person against whom such order is made. So, if an application was filed under 92 and that was disallowed, then no suit is to be maintainable. Perversity on the face of it. Order 21, Rule 92, Millard, is a procedure.
Just like you see the other 101.
Exactly.
There is an express bar.
Bow down. Bow down. So if there was a proceeding under 92, nobody could have challenged it, Millard, and there was an order, Millard, under 92. The person who, Millard, suffered that order could not have filed a suit. Now, I asked this question to myself, how is it relevant in our case? There had to be some proceeding, Millard, under 92.
You see, there are alternatives.
Yes,
Prior to the sale being absolute,
yes, Millard.
that can be set aside also.
Absolutely.
That power is given.
Absolutely given. But a person needs to know that there is some sort of proceeding going on.
All persons affected thereby.
So no orders can be passed under Order 21 to 92 if everybody is not given a notice. And my affectation, Millard, I need not
There
even
is no
open my
suit
mouth.
to set aside an order made under the yes by
Made under this rule.
any person.
Made under this rule.
When
This
there is a
is very
proceedings under this rule.
So there are no proceedings under Order 21 Rule 89. This is not a proceeding under Order 21 Rule 89. He needs to, Millard, the learned judge has gone perverse on this finding as well.
So it is according to you, it is under Rule 72.
Has to be. Has to be. The facts of our case is under 72. Millard imagines. Imagines, Millard, for 700 rupees, the entire Boshod Bari, the entire farmhouse, the entire farm.
No, that point of time, it was very valuable.
Yes, Millard, but
950 and 1000, very valuable.
Very valuable, Millard, but for that amount of money, Millard, the entire thing is going. And it's not that I haven't paid. It's not that haven't paid a single dime. I have paid. And I would have even paid even more. When the time
if your suit is not barred under law on the point of maintainability, then you have to argue that issue. You will not be able to complete, I believe, within half an hour.
It will take a little bit. I'll come back on the next team whenever you lodge.
Yes. Learned, Mr. Yes. Mr. Chatterjee, learned advocate for the appellant submits but could not conclude the submission. Let this matter appear on.
6th August.
Yes. 6/8/2026 at 2 p.m.
Earlier it is finished, your lordship will have. it
I
back in the
I can do one thing. I can keep it on 1st August. Are you agreeable?
Yes, Lord, I am agreeable, Lord. I am agree. I have got no choice. But I am agreeable.
Whether your learned friend will be agreeable?
Yes, that Mr. Chatterjee.
There will not be
Lord,
much work. So at 2 p.m. you can do argue as
keeps
much
it at-
as you like.
Keeps it at 10:30.
এক
I will do that. I'll finish it off.
এক তারিখে করে দেন। নিয়ে আসতে
করে
হবে কোনো ইয়েদের শনিবার ওই কম্পেনসেটরি হবে।
Huh?
Shall I keep it?
There are a lot of
কটা আছে?
আচ্ছা তাই 6th is okay.
ঠিক আছে থাক 6 তারিখে থাক।
তাই 6 তারিখ এসে আবার বসে থাকতে ভালো লাগবে না সেদিন।
No, because at 2 p.m. On that day after 2 p.m. there will hardly be any work
I don't think even from 10:30 your lordship will have work.
unless both sides are present.
Yes, and there will be some sort of resolution, I'm sure. Like tomorrow, my lord, we've taken a resolution because the
But
High
both
Court.
sides are not present.
Yes, High Court probably, my lord, nobody is going to come.
Anyway,
My lord, it was only last year this was introduced. In my 25 years and Mr.
oh,
Mukherjee.
there was a compensatory working date.
Yes, on the last occasion.
Yes, no, last year also.
There was a
There was a compensatory working date.
Closed that as well. We closed that compensatory day work, if you remember.
We took some, Lord, the pretext and had it.
Yes, we had it
Some,
closed
no,
that
no,
day
some
also.
matters were taken up on that
Very
compensatory.
few. My lord's determination probably, my lord.
Those civil revision, admission motions,
Yes,
those can be taken
can
up.
be taken up, and they can be done online as well.
Yes, yes.
These matters can't be done online.
Yes. It will take a lot of time.
Lot of time. This can't be done.
It is only possible on a particular this type of days. First, start from 11 and continue.
And finish it off.
That is the only remedy.
Earlier, my lord, we had, even when I came in, Mr. Mukherjee, even earlier, there were 2 second appeal benches who would only hear second appeals, nothing else. Nothing else.
Right.
And we remember, my lord, reading the paper books till our seniors came in. I'm sure Mr. Mukherjee also. They would come in and we would start, and that's how we learned. Nowadays, my lord, second appeals hardly.
Right.
My lord is there and Justice Mojumdar is there, but he hardly taken up. My lord.
Yes, but I am ready and willing to take it up.
Yes, Lord.
Look,
Second appeals are, Lord.
Both of us actually complained somewhere that please, but my lord, that matter I mentioned, my lord, that matter also Mr. Mukherjee is in the other side.
Yes, Mr. Mukherjee is for the appellant.
He's for the appellant.
No, when is that? When is the matter?
Lordship has not fixed. Huh?
Texans আয়
Vishwajit Basutta. Vishwajit Basutta.
ও ওইটা আচ্ছা আচ্ছা তাহলে তো ওটা একবারও শুনানি হয়।
হ্যাঁ
No, that company matter. Companies.
No,
my lord,
absolutely new
this
matter.
is a new matter. My lord, I mentioned online that day, my lord. My client was 88 years old.
Anyway, it will appear as to be
To be
mentioned.
mentioned, your lordship. has-
Thereafter, date will be fixed.
Yes, kindly, my lord, if it appears tomorrow or day after, if the file has come, দেখো না, to be mentioned is next week it will be mentioned.
Tomorrow, nothing will be taken up hardly. So next week, definitely date will be fixed.
Great.
All got the report from the register Lojima regarding the reconstruction of
It is a disposed of appeal, Millet.
this.
Yes.
It's a disposed of appeal.
So matter was remitted to. Matter was remitted
Yes,
to trial court.
Trial court, yes.
দেখি রিপোর্ট এসছে কিছু?
Report has come. So direction will be given to the department to supply the copies.
Yes, you are informed over the phone by the department.
Actually, I do not.
Yes, record an order. In terms of earlier order dated 30th June 2026, the Registered Administration L and OM has submitted the report. In terms of the report, the certified copies of the document in FMAT 21 of 2020
Which were applied.
is made ready, and the learned advocate is to collect the copies of the said documents. Thus, steps may be taken by the learned advocate for the parties to collect the relevant documents from the department in terms of the said report. উপরে লিখে দেবেন learned advocates for the parties represent. So take steps to collect the documents.
Milord, item 10 is also disposed of.
এটা রেখে দেন। Item 10.
10 is also disposed of appeal, Milord. My lord
Correction
had,
to be made.
Milord, my lord had passed an order for reconstruction because, Milord, the order could not be uploaded. The documents were not
Mr.
available.
Rai is appearing.
Mr. Rai, Milord, I am told that he's online, Milord. Even if he's not, Milord, the Milord, paper book Amit Ranjan Roy. Milord, the reconstruction has been done. Milord, your lordship will kindly record that and upload the order, my lord's order, Milord. It's a disposed of appeal, Milord.
No, I have to see the order. Okay. No,
Yes.
I have signed the order also.
Milord, my lord passed that order, Milord, and then
So let the order be okay. The order is placed before me.
yes. Since the Milord, the other documents were not there, it was my lord's Milord observation that that file be reconstructed. Online ache?
Yes, Lordship.
No,
Lordship,
both
I have supplied.
of you should also peruse the order, whether anything has to be rectified or not. Anyway, that can be done even after signing the order.
Yes, your lordship will
Yes,
approve.
Lordship, yes. And Lordship, I have supplied the entire papers, entire paper book, memorandum of appeal, everything I have supplied. And all the papers in the bottom I have signed.
Disposed of. একটা হয়নি, 4-5 হয়নি। জজমেন্ট হয়ে গেছে আগে।
Kindly unmute me, Mali. Kindly unmute me.
Yes.
Lordship, that papers are all the papers are filed, Lordship. And Lordship, kindly
সেটাই অর্ডারটা কি হ্যাঁ এবার তো দিয়েছে এটা তো দিয়েছে এটা এগুলো দিয়েছে আর কি হ্যাঁ This record in terms of earlier order dated 30th June 2026 is reconstructed. Let this matter appear on 22nd July 2026 at 4 p.m. On that day, I shall sign because some corrections are being made.
Lordship, already disposed of the appeal.
No, corrections made. On that day, I shall sign and thereafter direct to upload the same.
My lord, this would appear under the heading for judgment. My
No, to be mentioned.
lord.
And Lordship, one liberty kindly granted to file a further Vokalatnama. Sir, further Vokalatnama required to be filed.
On the next day, I shall pass that order.
Lordship.